Good morning. Welcome to the August 9, 2023 Santa Barbara County Planning Commission hearing. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Ms. Castro, would you please recite the TV coverage announcement?
Yes. Planning Commission hearings are televised on County Santa Barbara Television CSB TV Channel 20 at 9 a.m. in South Coast, Lompoc, San Ynez Valley, Santa Maria, and Orchid areas. Rebroadcasts of Planning Commission hearings are on Fridays at 5 p.m. on CSB TV Channel 20. This hearing will also be streamed live on CSB TV and will be available for download in a day or two.
Okay, and would you go ahead with the roll call?
Yes. Commissioner Cooney?
Here.
Commissioner Briley? Commissioner Fernie?
Here.
Commissioner Martinez?
Here.
Commissioner Park?
Here.
Thank you.
All right. Mr. Wilson, can you give us the agenda status report?
Good morning, Mr. Chair and Commissioners. In regards to the status of the agenda today, there's one item on consent, and then there are 3 items on our standard agenda. The continuance of the appeal of the Roundup Road entrance gate, as well as we had continued the Strauss Wind Energy Project today. Those are the first 2 items, and then we have a development plan for a water tank on the agenda today as well. And it is my understanding that you did receive a memo late yesterday in regards to the first item, which is the gate. It appears that the parties have reached an understanding, so we'll proceed with that item today. And then staff will be presenting on, we'd continued the Strauss Wind project, and staff is going to be able to present on that as well as far as findings for that project. So that concludes the status of the agenda, and I can move the projection report, Mr. Chair.
Okay, let's do that, if you will.
So our next meeting is going to be on August 30th. It will be here in Santa Maria, and the item on that date is a workshop in regards to amendments to the comprehensive plan and the zoning code amendment, zoning codes, LUDC, and potentially Article 2 in regards to implementing the Recreation Master Plan. So that is on August 30th. It'll be a workshop on amendments related to the Recreation Master Plan. Following that date, we had canceled the September 6th hearing, and then we will be returning on September 13th, which has 4 items on it. We have a appeal of a cannabis cultivation in Carpinteria. Actually, there's 2 appeals on that day of cannabis operations in Carpinteria. Then we have an appeal of a telecom in the Isla Vista area, and then Long Range Planning is going to be presenting on the environmental justice element of the comprehensive plan. And that is, again, September 13th, and that will be here in Santa Maria. Following that, our next hearing is on September 15th. Oh, that's not you guys, that's Montecito. We will be returning on September 27th. As of right now, there's 1 item, which is we had continued the homestay to that date, I believe. The appeal of the homestay is on that day. Actually, I take it back. That's a new item. We didn't continue it. Starting to get back in the groove. My apologies. That's a new item. It's an appeal of a homestay on September 27th.
Where's that homestay?
It's in Los Alamos.
Okay.
On Coiner Street. Then on October 4th, we have another telecom project on the agenda, as well as the Long Range Planning Division is going to bring ordinance to the Planning Commission in regards to additional changes that we're trying to align with the state for accessory dwelling units. As of right now, there's no items agendized for October 11th, and then October 25th, we don't have any items either. So that concludes the projection report as of right now.
Okay. I think on the 27th of September, we ought to schedule that as our follow-up day for the Rec Master Plan Workshop. Fill out the day. Yeah. Okay, does anybody else on the commission have questions of Mr. Wilson about the projection report or the agenda status report? Is something what? Okay, Commissioner Briley?
Oh,
Do you
I'm
have a
sorry.
question?
No.
Okay. Okay. Well, let's move on to public comment. And this is public comment on items that are not on our agenda today. I'd ask you to limit your comments to 3 minutes if you can, and we'll have a total of 15 minutes for public comment if there are that many speakers. I've never seen it in my years in the commission, but there's always a first time. Okay, do we have any public comment here in the room? And Ms. Castro, do we have any public comment for people that are online or on the phone or whatever we call it?
Chair Park, we do not have anybody online.
Okay, then let's move on to Planning Commissioners' informational reports. Do any of the commissioners have an informational report they want to provide? Well, then how about the minutes? Anybody have any comments on the minutes for the hearing of July 26, 2023? And will anybody be willing to make a motion to approve those minutes then?
So moved.
Is there a second?
Second.
All in favor, please say aye.
Aye.
Aye, the motion's carried. And let's move on to the director's report.
Good morning, Mr. Chair, members of the commission. I have a pretty brief report today. It's summer, so the board's out on their break, and so things are a little bit more quiet than the rest of the year. I did want to, again, remind everybody about the Planning Commissioners Conference in Tuolumne County, October 6th and 7th.
That's right.
And then also let everybody know about the California APA State Conference. That is in Fresno this year, and that is from September 16th to the 19th. That also has options and sessions for planning commissioners generally. So if you're interested, it's something you could certainly take a look at. The Planning Commissioners Conference is really more focused on planning commissioners. And then just a quick update on the housing element process. We're just undergoing a conversation with the state to ensure our responses to their comments are adequate before we formally resubmit. We are expecting that to take maybe a week or two, and we're hoping to formally resubmit maybe next week or the following week. And we have to post for 7 days for the public to have an opportunity to see the changes. The public can certainly submit something in writing if they want to, but it's not similar to the 30-day public comment period that we have at the beginning of the process. This is more for transparency purposes, but whatever does get submitted, we will transmit to State HCD as part of our packet. And just another reminder about the Ag Enterprise Ordinance, EIR being out for public review. The environmental review hearing is August 21st at 6 p.m. It's a virtual meeting, so people can participate virtually. And let me see if there's anything else. I think that is it. We have future board items. The appeal of the Pacific Pipeline Valve project is on August 22nd. The Coastal Resource Mitigation Fund is on August 29th. The change of ownership for Las Flores pipeline is September 19th. The appeal of the Calinks Cannabis Project is also September 19th. And then there's a garage conversion appeal, Garrity Garage, on October 17th. I know that they're working on getting the environmental justice elements scheduled also for the board, but I don't have a date specific for that just yet. And I'm happy to answer any questions.
I have a question.
Oh, yes, Commissioner Cooney?
Thank you, Mr. Chair. Good morning, Ms. Plowman.
Good morning.
Just one quick question. You reported at our previous meeting last week that you were attempting to conference with the state housing people before submitting, and I thought you said about the same today. Are you having resistance in being able to get answers to?
Yeah, thank you for asking that question, Commissioner Cooney, through the chair. Our reviewer was out last week, and so we didn't have it. He didn't have a chance to take a look at anything. So we are conferencing now. We've sent the information over. He asked us to wait until he got back. I didn't have any new information, but we're not having any difficulties with them. They've actually been very helpful and facilitated the process.
Thank you. That's perfect.
Sure.
Okay, this is more of a musing than a question. And I in your recitation of the matters that will be heard on appeal before the board, I counted about half a dozen, and some seemed very important, and some seemed kind of lower on that scale. And when I look at board agendas, they're pretty darn long, and I think it's unfortunate that so many matters come out of here and wind up on appeal with matters of such differing natures and importance. And if anyone could ever suggest something as to what we could do at the Planning Commission level or what we could suggest for changes in county procedures, so not every single thing goes up to the board. Because some items, the board wants to hear them, it's going to come to the board, it's going to have important policy considerations, and some, there's not a snowball's chance in hell that the board is going to reverse the Planning Commission determination on some of these items. And so it seems like it's just a waste of the board's time. So that's why this is amusing, not a question. I don't expect any answer at all.
Mr. Chair, I'm happy to talk with you about it at a later date. We can talk about some potential strategies, but we've observed the same and have been talking internally about ways we might be able to alter the circumstances so that we can minimize the number of appeals that go to the board. Yeah, I appreciate that.
Okay. Well, then,
that. Ms. Plowman, years ago, I remember that when something is appealed to the board, there's a mandated mediation meeting between county council and the applicant and appellant. Is that still in place, that process?
Yes, Commissioner Bradley, through the chair, that is still in place, and it is offered to the appellants, and sometimes they take advantage of it and sometimes they don't. We were able to resolve, it wasn't an item that came through the County Planning Commission, but it came through Montecito, and it was the Coral Casino changes, and we were able to resolve those partly through the mediation and then different conversations between the appellants and the applicant. But we do work hard to try and get those issues resolved so that we can lighten the load for the board.
It's just good to be reminded about that. Thank you very much.
Sure.
Chair Park and Commissioner Bradley, I'll just add, we offer facilitation of the parties sometimes, and both need to be willing to move forward for us to do it. Sometimes one or both are not interested. And it's also for third-party appeals. So if you deny a project and it's appealed by an applicant, we don't offer facilitation because there's no discussion between two parties to be had.
All right.
Sure. So let's take, for example, this gate today. So if the Planning Commission approved the project and the neighbors were still upset and appealed it to the board, we would offer facilitation. But if you denied the gate and the applicant appealed it to the board, we don't offer facilitation because they're the applicant and the appellant. So it's sort of not two parties to bring to a meeting of the minds. And then applicant can still work with planning during the appeal process if there's any change.
You know, I'm glad you brought that up, though, because I can remember several mediations I had with Bill Dillon before he retired. And county council does a really thorough job on these mediations. They take it seriously, and it's something everybody should avail of if they're involved in an appeal. Even if you don't settle the matter, you'll at least kind of narrow the parameters of what you'll be having a controversy over. So it's well worth your time. Okay. Any other questions of our director? And thank you.
Thank you.
Let's move on to our consent agenda. We have one item on the consent agenda. If somebody has comments on it or questions or wants to address it, otherwise we can pull it off. Otherwise, we'll just vote on approval of the consent agenda. Okay. And is there a second?
Second.
And Ms. Richardson, do we need open this to public comment on just approval of the consent agenda?
Mr. Chair, you can offer it or call for it. I doubt there's anyone here.
Let me do that. I think the public should have a shot somewhere in that process. Do we have any public comment on our consent agenda or a consent agenda item today? Okay, we do not. So let's vote on the motion. All in favor of the motion to approve the consent agenda, please say aye.
Aye.
Aye. And that motion is carried. And we'll move on to our standard agenda. And Ms. Castro, could you read the first item into the record?
The following is hearing on a request of Susan and Rick Weber, appellants, to consider case number 23 APL 00019, an appeal of the Planning and Development Director's approval of a land use permit, case number 22 LUP 500035.
Okay. Do any of the commissioners have ex parte contacts or site visits to report?
I do, actually. I
Commissioner
almost
Bradley?
forgot about this, but about a week and a half, I had a call from, I think, the owner. I apologize, I didn't write this down, but the owner of the site asking about our action as referenced in the staff report, and I just talked to him about maybe consulting with staff or his agent, and the concerns of the commission, and I tried to get them back over to staff. So that was, I apologize, his name, the owner is not in the memo. I think his name is Rick. Maybe, what, Ross? Russ, thank you. That's all.
Well, I'm glad he chose you to call. I think the rest of his commissioners will refer all our future calls of that sort to you. You handle it very well. Yeah. Well, that could take all day to explain. Okay. Then let's move on with our what would we call it? Staff report, status report, memo. You call it. Just do it.
Chair Park, we have Ben Singer remote, so I think he's going to update you on where we're at with this project. Ben, can you hear us?
Yes, I can. Can you hear me as well?
Yep, thanks.
Perfect. Good morning, Chair Park, members of the commission. I am back before you today with the Weber appeal of the Roundup Road Gate, which was previously heard on July 12th, 2023. As Secretary Wilson mentioned, your commission received a memo late yesterday with details about the agreement between the applicant and the appellants. Next slide, please. Just to quickly review the project, the location is shown here with the star. It's off of Brinkerhoff Avenue, which comes off of Roblar Avenue. Next slide, please. The project is for validation of an existing entrance gate and decorative wall, as well as installing new landscaping and removing a no outlet sign. As is detailed in the memo from yesterday, the applicant and the appellants have come to an agreement to change the tile on the roof of the gate. The language that has been added to the project description is included here and reads, the existing roofing material is proposed to be replaced with an unglazed two-piece barrel roof tile in a Tuscan blend color range. Next slide, please. With this agreement and that change to the project, staff recommends that your commission deny the appeal, case number 23 APL 19, make the required findings, including CEQA findings included as attachment A to the most recent memorandum, determine the project is exempt from CEQA, and grant de novo approval of the revised project, case number 22 LUP 35, subject to the revised conditions included in, again, the most recent memorandum. Just a quick presentation, not too much to go over on my end, but I am happy to answer any questions that the commission has. Thank you.
Does anyone have questions of Mr. Singer? Okay. Do we have any presentation by the appellants? No. Do we have any presentation by the applicants?
Oh, the door was locked. I couldn't get in. Do you want me to come up? Is this us? Yep. Okay. We're good.
Okay, you got to kind of tell us who you are.
Okay, hi, sorry. I'm Susan Weber.
All right.
Hi. We've been talking to the Allens. We have come to a wonderful agreement. We have the tiles, and as long as they use these tiles, we are good to go. We're happy, and I don't think any further action needs to be taken.
Okay, thanks.
Okay.
And applicant, do you have anything to report?
My name is Elsa Reeder. I'm representing the applicant today, and we are happy to have come to an agreement and are okay with the proposed change to the project description.
All right.
That's what I have to say.
Thank you. Do we have any public comment? Ms. Castro, we have anything online?
Chair Park, we do not have anything online.
Okay. Then it appears there's no need for rebuttal. I'll ask staff if you have any last word on this.
Nothing
Sarah
from
Park.
staff.
Answer
Yeah,
appears to be
nothing from us.
no.
Thank you.
Then we'll close the public hearing, go into deliberations. Do any of the planning commissioners have a comment? Commissioner Freeney.
Yeah, I'm pleased to see that the applicant and appellant got together and solved this themselves, and just good to see. So
Thank you.
I'm ready to
And
vote for approval.
all righty, Commissioner Cooney.
I would echo what Commissioner Freeney indicated and say, in addition, this is the kind of appeal brought to the commission that could continue on to the Board of Supervisors, and I'm confident that won't be necessary. Hearing from the parties and applaud their efforts to avoid significant amounts of time for themselves and for the board and staff.
All right. Would anyone like to make a motion?
I'll move.
Okay, Commissioner Bradley.
With particular appreciation to the applicant and a willingness to reach out, and also the appellant. So I will move staff's recommendation, which is to deny the appeal, case number 23 APL 00019, make the required findings for approval of the proposed project specified in attachment A to the memorandum, including CEQA findings, and the memorandum dated August 8th, 2023. And also to determine the proposed project is exempt from CEQA pursuant to guidelines 15303 included as attachment C to today's memorandum, and grant de novo approval of the proposed project, 22 LUP 500035, subject to the revised conditions of approval included as attachment B in today's memorandum.
Second.
Any further discussion of the motion now that it's been made? No, then it will, all in favor, please say aye.
Aye.
Aye. The motion's carried unanimously. All right. Let's move on to item number 2. Will you please read that into the record, Ms. Castro?
The following is the hearing on the request of Strauss Wind LLC Strauss, an affiliate of Bay Wire Wind LLC, to consider case number 23 RVP 00031 for approval of a revision to the Strauss Wind Energy Project, conditional use permit number 16 CUP 500031, condition of approval number 38 MMBIO 16.
All right. Do any of the planning commissioners have either site visits or ex parte contacts to report? Commissioner Bradley?
Am I
Okay.
still on?
All right. I do. I had a meeting with Steve Ferry of the Audubon Society chapter on Friday afternoon. And I received an email with a letter earlier that day, or maybe it was the day before. And that letter, I asked that it be sent on to Mr. Villalobos or Ms. Castro for posting, and I think it was. And then I spoke with folks from the from BayWa. I think it was Monday, and then again yesterday. And those are my ex parte visits. Okay. First, let's take up whether we have late filed letters to approve. I couldn't tell from looking at the letters when they'd been, the ones that got posted Monday afternoon, when they'd been submitted. And I saw them relatively late Monday afternoon, so it made me wonder whether they'd been submitted by noon or not. Do you know, Ms. Castro, do we have anything that's late filed that we need to look at?
I am looking up that information to see when we received it. Give me
Okay.
a minute. So they did come in the morning, Monday morning.
So
That's
we
when
have
we received
nothing
them.
that's been late filed.
We do not.
Okay, excellent. Well, then let's go ahead with our staff report. Is that Mr. Briggs behind the monitor? There you are. So, is Ms. Ibarra going to do it, or is Mr. Zorovich?
Good.
Take a pick. You could all do it.
Good morning, Mr. Chair. Yeah, who's behind door number 3, right?
There you are.
For this morning, we have Ms. Jacqueline Ibarra is going to be giving the staff's presentation. Thank you.
Okay.
Yeah, good morning, commissioners. I'm virtually online. So we are also back today regarding the Strauss Wind Energy Project's proposed revision to Condition 38, and this is regarding their U.S. Fish and Wildlife Service Golden Eagle Take Permit. So next slide, and we can get into it. So this project was last heard by your commission in July. It's a request to approve It's a request to revise an approved conditional use permit to allow Strauss to operate prior to obtaining a Golden Eagle Take Permit, or an ITP. So Strauss has argued that it's no longer feasible to obtain the ITP prior to operation. One of the reasons is because that permit has a very lengthy processing time, and they plan to start operations this fall. So staff originally recommended denial of the project. However, at the July commission hearing, the commission did find legitimate reasons to approve the project and requested that staff return with findings for approval and revised conditions that added some additional monitoring and reporting requirements. So the applicant agreed to these changes, and those are detailed in the staff memo that you now have dated August 1st. And I will briefly go over the changes this morning. Next slide, please. So this slide summarizes the Commission's reasons to modify the condition and approve the project. As a reminder, these are needed because CEQA requires that changes to adopted mitigation measures be supported by legitimate reasons based on substantial evidence. These 8 reasons were described by the Commission during your previous deliberation, and they are detailed in the staff memo that you have, as well as in the revised findings. Next slide. And this slide goes over the monitoring and reporting requirements the Commission recommended be added to Condition 38. So now that condition includes a requirement for staff to report to the Commission every 6 months regarding the status of Strauss's ITP application. The applicant shall also report to the Commission every 2 years, and the applicant shall provide a copy of the ITP once it's issued. And then we just wanted to note here, since it was brought up by the Commission in the last hearing, in the unlikely event that the ITP is denied, the Bird and Bat Adaptive Management Plan, which is a separate Condition 42, could be reevaluated through a subsequent formal CUP revision. Next slide, please. So for environmental review, we're relying on CEQA guidelines, section 15162, that doesn't require any subsequent environmental review for projects that don't have any substantial changes or new information. We know the previously certified EIR analyzed impacts to Golden Eagles and that the project doesn't meet any of the triggers for that subsequent review. Next slide, please. For consistency analysis, the staff memo and the revised findings now show that the project is consistent with the LUDC, specifically for the requirement that CUPs, that significant impacts be mitigated to the maximum extent feasible. And this was the only consistency analysis that needed to be revised. So the memo and the findings now describe that the project would provide no less protection for eagles and that impacts do remain mitigated to the maximum extent feasible, as all minimization efforts would be in place prior to Strauss starting operations, and they remained obligated to obtain the ITP and implement any compensatory mitigation. Next slide. So for findings, attachment A to your staff memo describes that all findings can be made. The list here just shows which findings were revised from the previous version. And again, details are provided in your staff memo. Next slide. So in conclusion, staff recommends that your commission, 1, make the required findings for approval, 2, determine that the previously certified EIR is adequate and that no subsequent environmental review is required, and 3, approve the project case 23 RVP 31, subject to the conditions of approval. Next and last slide. And that concludes our presentation, and I'm happy to take questions.
Okay. Do any of my fellow commissioners have questions of Ms. Ibarra? Okay. Mr. Martinez.
Well, good morning, everyone. Yes, on the one page which is indicated as additional requirements, let me speak into this, that additional requirements, the note that, the last note, which reads, if the take permit is denied, the Bird and Bat Adaptive Management Plan could be reevaluated. I'm wondering if you can give me a broader definition of what reevaluated would consist of. Would that mean it's not needed anymore, or? If you
Sure, Commissioner Martinez, through the chair. So if they don't obtain their ITP, then they would be in violation of their CUP requirements. So they would have to, they could return to the board, and the board could evaluate if the adaptive management plan is still adequate to provide those mitigations. or if the board would want to revise that adaptive management plan to include any additional monitoring, reporting, mitigation measures, et cetera. So it's not that it wouldn't be required, it would just give the commission the opportunity to go back and look at it to see if anything would need to be revised.
Okay, so in my mind, what I'm hearing is that if the permit is denied, then this project could still go forward without that permit. It's just that we'd have to go back and strike that from a previous condition. Is that a fair?
Commissioner, through the chair, if the ITP is denied, I'm not sure if the project could move forward because they would be in violation of condition 38, so it would need to be reevaluated.
Okay.
Maybe Aaron has some additional comments on that.
And that's what I'm trying to get to. The reevaluation could mean the removal of that condition is what I'm getting at, or not. That's my question.
So, Mr. Chair and Commissioner Martinez, so if the ITP is denied, there would be a need to, the project would be in violation of that condition, right? Because the condition says you have to obtain the ITP. So that's the starting point. The project would be in violation of that condition. The project would return to the decision maker, and the decision maker would decide, in lieu of not obtaining this ITP, what do we do now? And at this time, we don't know what that looks like, right? It could be any number of things. And I would anticipate the decision maker would say, well, if we don't have an ITP, we need to do something about this. And they would head in a direction of requiring some other type of mitigation, or requiring the applicant to re-engage with U.S. Fish and Wildlife and try again for the ITP. We would need to come up with a suite of alternatives at that point if that happens.
Okay, well, thank you, because that answers my question. I'm not trying to put staff in a box, but basically, you just answered my question. The top of the box would be open, and whatever decisions would have to be made at that point. Okay, and then also in regards to the reasons to modify condition, that was the third page. I'll just say that I'm not comfortable with the number 8, which says provides no less protection. I believe at least what I was perceiving in regards to is that the last part of it, potential impacts remain mitigated to the maximum extent feasible, at least for the time being. I mean, I just wanted to say that on the record for my comments. I don't know if this is the time, since I'm the newest one on this commission, is this the time we address any of these letters, or we just kind of wait down the road when we go into discussions regarding this?
I have the same question in my mind. That is, we staff has certainly seen the letters, and we can ask if they have any reaction to those, or we might wait until we hear from the public speakers that might be speaking to those letters. I think that's probably the better time to do it.
I would agree. Thank you.
Yeah. Are you done, Mr. Martinez?
Yes, thank you.
Okay, I thought you asked an excellent question. I want to follow up on that, the one regarding the note that was on the slide. Could you go to that slide? I think it was like the third or fourth slide. There you go. You're just there. I think it's go backwards. Or the slide that had the note that Mr. Martinez was referring to. There you go. And I think that's well worded. I think it's responsive to something I asked for at the last hearing, and that was that were the take permit to be denied, then that would be treated as a triggering event under the conditions of approval for reevaluation of the operation of the facility. And this says more or less same thing. What I don't understand is the reevaluation automatically initiated and then put in front of the Planning Commission, or does BayWa need to initiate it? Who would initiate this reevaluation for a subsequent CUP revision?
Mr. Chair, so Again, the ITP gets denied by U.S. Fish and Wildlife.
Right,
Staff immediately recognizes that as a violation of this condition
right.
and recognizes the need to return to the commission or the board and come up with some type of modification to this condition. The condition says you have to get an ITP. They can't get an ITP. How do we resolve that? So we come back, staff would come up with some suite of alternatives, some suggestions for the commission. Commission would go through their deliberations and decide what's appropriate, and then we would go from there.
And in that suite of alternatives, doing it that way, can one of those be modification of the operating conditions?
Absolutely.
Okay, because that's a potentially draconian remedy, which is very important here. I mean, it could mean saying, you know, the eagles are out hunting on every third Monday morning, and don't run the turbines then. Or maybe you're just killing so many of them, and it happens all the time, we got to shut it all down. I don't know.
And Mr. Chair, the adaptive management plan already includes curtailment options.
Right, but that's, you know, it's now triggered by, I think, the loss of 2 eagles.
Yes.
And that's what I was getting at, is perhaps a triggering event should be added to the list. That's the denial of this take permit. But what you've done in the note basically solves that situation. I mean, and I just want to make sure we'd have the same remedies available at that time as we would with something that was more explicit, like I suggested. Okay.
Yeah, we believe that you do.
Okay, well, I think that's well thought out. I did want to compliment staff here. I think all the staff reports we get here at the Planning Commission are really good, really well thought out. But it must be even harder to take something that is to write up our kind of inchoate thoughts from the Planning Commission that run counters to staff's initial recommendation and then put it in an articulate, reasonable manner. And I think that was done very well here. So I really appreciate that. Okay, anyone else on the Planning Commission with a question for now? All right.
Sorry.
Commissioner Briley?
I know you covered this, but just in case people are listening, the concept of curtailment means we could request, as part of those deliberations of the suite of alternatives, is just to stop the operations altogether if the ITP isn't issued. Correct? We could go that far.
Mr. Chair and Commissioner Bradley, I don't know how to answer that question.
Okay.
I mean, certainly the adaptive management plan considers curtailment under certain circumstances, right? Running the wind farm at night, running the wind farm outside of the eagle season, things like that. It does not anticipate full shutdown of the project. That is,
Okay.
I think, a level of curtailment that we had not previously considered. And I think that action brings on a whole set of its own issues. So, you know, I don't know where to go exactly with that question.
That's okay. That explains it just fine. We've been criticized by some members of the public, and I know this will get into deliberations about, having this sort of perceived relaxation of the condition. And I think that a lot of folks don't really understand how tight the remaining conditions are in terms of any kind of incident. So, okay, so not full curtailment, because that brings in a whole other host of issues, but everything up to that. Thank you.
Well, I understand Mr. Briggs' answer to be not necessarily yes or no, but that clearly a complete cessation of operation brings in a whole host of legal arguments that would be made at the time. And I think that anybody that follows eagles and their natural history in this county, they migrate. So there's a strong migration in late fall. and they have different hunting times and so forth. And so the likelihood that it would have to be curtailed for every minute of the day, every day of the year, is probably unlikely, but we'll see at the time, if we ever get there. Okay, do we have an applicant's presentation?
Mr. Chair, I just had a
Commissioner
comment
Cooney,
for
I'm
me.
sorry, I missed that.
I just want to express the view that we're taking up issues, I think, that jump ahead of the action that's before us, and I'm a little uncomfortable speculating as to what we might do if we take a particular action today. That's for deliberation. I want to get through the current agenda before we talk about something in the future.
Thank you, and I think the use of the word speculating is particularly choice here. So let's move on to applicant's presentation, if there is one.
Thank you very much, Commissioners. I'm Gordon McDougall. I'm the CEO of Bivalve Wind. I don't actually have a presentation. I just wanted a short statement to thank the Commission for their patience with this, thank the staff for their diligence in providing a robust condition for us to consider. We're obviously very comfortable with what's been put forward to us. I would just like to give a brief update that we've executed our contracts in terms of the West ecosystems for the avian studies that are required for all of this to meet the condition. All the identified units that we've talked about that would manage that curtailment and identify any eagles anywhere near the site have all been installed. Their commissioning is continuing this week, and they'll be fully operational for the date we would go live with the wind farm. We've completed all of our applications with US Fish and Wildlife Services. The permit's all in place to move forward. We have meetings with them and the consultants that they've appointed under the NEPA process for this week. So all of our actions are in play. We're happy to meet any of the requirements that will be put in front of us for this permit. In terms of the last conversation around what would happen should a permit not happen, we're not necessarily contemplating that scenario because we believe we will have a permit. We will comply with the permit. There's a very robust set of conditions there. I think, as you outlined at the last hearing, and I think it's a very important factor for all of us to consider, is the adaptive management plan that has been applied here is much greater than any federal system. That is a more robust and more strong set of conditions for us. So that would always be greater, but we will always meet the federal requirements that are there for us. So I have no further comments at this point.
Okay, and we'll give you rebuttal time as well after public comment. As various speakers might suggest alterations to the plan here.
Okay, I'm happy to address that. Okay, thank you.
Then let's move on to public comment. Ms. Castro, do we have anyone online or on the telephone for that?
Chair Park, we do have two speakers.
Who are they?
We have Tony Francosis and Maria, can't pronounce that name, but Maria K. And then we have a in-person speaker as well.
Okay.
So Tony, we'll start with you.
Well, actually, I was going to start with Mr. Caldwell.
Okay.
And
apologize.
And you being the only speaker from the audience, Mr. Caldwell, I think are you speaking for all of the public? Probably not, but
actually,
but anyway, whoever you're speaking for, take no more than 3 minutes, please.
Well, thank you for that.
Thank you.
Unfortunately, I didn't know that first item was going to be settled. I told people to show up at 10. My mistake. So, Chair Park, thank you for letting me be here. I'm Andy Caldwell, the Executive Director of CoLab. What we're talking about here, of course, is the symbol of the United States, a national bird, the poster child of the ESA, the first species listed under the ESA. Also, we have the Eagle Protection Act and CEQA. And you have a certified EIR, which is filed with the state of California. It's a Class 1 impact. The only mitigation in the condition of approval for that Class 1 impact was the incidental take permit, not this thing, but issued by the U.S. Fish and Wildlife, which the EIR said is the only authority in this to mitigate the loss, monitor the program, and figure out what happens when they take. That's the only thing you've got. The entire EIR, as far as Eagles goes, hangs on the condition that is not, you cannot substitute a condition in a certified EIR that's dealing with felony activity. It's a felony. You have to reopen the EIR. You'd have to do a supplemental because now there's a new state law that there's a state take permit available. So not only do you have the federal take permit, which is in there, but now the new state law says there's a state take permit that they would have to apply for, not this. You know, your statement of overriding considerations, should you open that as we don't care about eagles or saving the planet from climate change? That's on the record. We don't think that flies. Your action, as our attorney has pointed out in his letter, would precipitate what's called a proximate cause take. That is a felony on your behalf. I don't have to tell you that the county of Santa Barbara got threatened with prosecution for a dead salamander that nobody could prove they had anything to do with the death of the salamander. They had to buy property for mitigation. The Santa Maria Airport had to give up property for mitigation for a salamander. We've had property owners throughout the region giving up property for one species or another, but you guys can say that because it's inconvenient, it becomes infeasible for them to operate? Nobody's saying they can't operate. They just have to go through the conditions. How does a multinational corporation fail to go down the conditions of approval and the required mitigation measures and forget the one that says, go get a take permit, which by their own admission was going to take 1 to 3 years? How did they forget that? Has anybody else come before you and said, hey, we forgot, let us operate anyway? Have you ever done that? Audubon Society and CoLab on the same page. You're setting a precedent here. Completely illegal. Thank you.
Thank you. You might take a look at a picture of the state or the national symbol, and they all have white heads on them. So they're bald eagles. But we love golden eagles as well, and I know you do too. There you go. We have no one else from the audience. Then let's go ahead with our, is it 2 online commenters?
Chair Park, we actually have 4 now.
4, okay.
So,
Mr. Caldwell revved them up. Let's get the, you take them in any order you want.
okay, we're going to start with Tony, followed by Maria.
Thank you. Can you hear me?
Yes, we can.
Thank you. And good morning, members of the Planning Commission. My name is Tony Francois with the firm of Briscoe, Ivester, and Basil, representing Santa Barbara CoLab. I'm going to highlight 2 legal problems out of the several that we addressed in our letter delivered Monday morning. The first is that as Mr. Caldwell just said, the only mitigation for golden eagle kills by the project in the current permit is a federal incidental take permit. And that when you are considering deferring that permit requirement with no new deadline to obtain it, what you're really doing is waiving it for as long as it takes the project to get one. As has been said, the proposed modifications don't substitute any other actual direct mitigation for the eagle kills. Project will simply comply with other permit terms that they are already obliged to comply with, and then let you know every few years how it is going with Fish and Wildlife. So there's nothing in your record on which you can conclude that waiving the ITP or deferring it will mitigate golden eagle kills to the maximum extent feasible, which is your obligation under CEQA. So you are leaving a known significant impact not mitigated to the maximum extent feasible. So this action on its own is subject to legal challenge, but it also undermines the previous overriding concerns decision and subjects that to new challenge. The law is pretty clear, actually, that the standard for concluding that an adopted mitigation measure is can be changed for legitimate reasons requires you to determine that it's infeasible or that it's not necessary. That requirement's got to be made by way of a supplemental EIR, and it's quite clear that the conditions that you're looking at now, the circumstances, don't meet the legal standard for infeasibility. And we've cited the cases that explain that in our letter. The second problem that I want to highlight is the California Endangered Species Act. Until a month ago, there was no way to obtain a California ITP for fully protected species like golden eagles. Now there is, because of an urgency measure signed by the governor on July 10th. Under new Fish and Game Code section 1081.15, wind energy projects like this one are eligible for an ITP from the California Department of Fish and Wildlife for golden eagle. If the commission wants to reopen this provision of the permit to waive or defer the federal ITP, then during this reopener, you have an obligation to analyze in a supplemental EIR whether the newly available state ITP would serve as an adequate substitute mitigation. And since the state ITP is now feasible and the project operator is here asking for a reopener on its permit, the county has a duty to require the operator to obtain a state ITP before operations. Thank you, and I'm happy to answer any questions.
Okay, thank you. And who's next?
Maria, followed by Lisa.
Hello, can you hear me? Hello?
Yes, we can.
Okay, I'm going to apologize in advance because my daughter, who's disabled, may be hollering in the background. I'm new to this subject, but anybody that has not even looked into it prior can find any information on the internet. For example, Next Energy subsidiary, ESI Energy, was sentenced to probation in order to pay more than $8 million in fines and restitution after at least 150 eagles were killed over the past decade at its wind farms in 8 states, according to federal prosecutors. Next Energy subsidiary pleaded guilty to 3 counts of violating the Migratory Bird Treaty Act during a court appearance in Cheyenne, Wyoming. It was charged in the deaths of eagles at 3 of its wind farms in Wyoming and New Mexico. In addition to those deaths, golden and bald eagles were killed at wind farms affiliated with ESI and NextEra since 2012 in 8 states. And so it's illegal to kill or harm eagles under federal law. The Bald and Golden Eagle Protection Act, 16 U.S.C. 668, 668D, enacted in 1940 and amended several times since, prohibits anyone without a permit issued by the Secretary of the Interior from taking bald or golden eagles, including their parts, including feathers, nests, or eggs. A violation of the act can result in a fine of $100,000 to $200,000 for organizations, imprisonment for 1 year or both for a first offense. Penalties increase substantially for additional offenses, and a second violation of this act is a felony. Well, there's other laws on the books, the Migratory Bird Act, Treaty Act of 1908, the Migratory Bird Conservation Act, which is federal law, migratory birds. There's a citation, Executive Order 13186. And so, I'd like to conclude that I oppose Agenda Item 2, where these companies basically do not have to follow the law. This is like a double standard, a double justice system, where we are pushing for more corporatism, or with other words, fascism, where corporations and bureaucrats in government get to decide what's good for the environment and what is not, and totally bypassing the rule of law and the will of the people. The will of the people is clearly stated in all these acts and federal laws that clearly forbid this company to act without a take permit. Thank you for your time.
Are you done?
Yes. I said, thank you for your time. Thank you for listening.
Let me ask you one more thing. I don't think we got your full name for the record.
Maria Kestner. Kaestner. It's on the screen, Kestner. It's my husband's name.
On the screen.
Yes, Kestner.
It's not on any screen that we have visible here, but thank you.
Oh, it is on the screen on my,
Well,
while
that-
I'm speaking.
But that's okay. We've got it now. Thanks a lot.
Okay.
Okay.
All right.
Who is next? And be sure to identify yourself in the first sentence of your presentation.
So up next, we have Lisa Sloan, followed by Barbara Davis.
Good morning. My name is Lisa Sloan. Good morning, Chair and County Commissioners. Thank you so much for the opportunity to speak to this important project today. I want to say that I do agree with the previous speakers and want to give credit to Andy Caldwell for some research that he's done in the past in regards to the wind farm on the Altamont Pass up in the Bay Area, which studies have shown they've killed it. That wind farm has killed 4,700 birds annually, including 1,300 raptors and 70 federally protected golden eagles. In addition, it's been shown in Northern California an 80% decline in nesting bald eagles as a result of the presence of this project. So, and also it was mentioned, well, we can run it at night, but don't forget that that's when the owls are out, another raptor that hunts at night. So I just hope the planning commissioners will consider do not open the county to potential lawsuits and ensure that all proper permits, federal and state, take permits are in place prior to approval of the Strauss Wind Energy Project. Thank you so much for your time.
Thank you. And who's next?
Up next is Barbara.
Good morning, Chair and Planning Commission, Board. Can you hear me?
Yes, and please identify yourself with your full name.
Yes, Barbara Davis. I would like to add my deep concern as a longtime citizen of this county about the possible modification of condition number 38 of Bear Bayware's conditional use permit for the Strauss Wind Energy Project that would directly impact the county of Santa Barbara and our wildlife here and set an illegal precedence over our government representatives, exposing the county to liability. First of all, I am opposed to using this little town of Lompoc by allowing this mega corporation to operate their wind turbines with a compromised modified permit that gives no more protection to our golden eagle. The serious and irreversible outcome of this action would be the wanton destruction by a violent and gruesome death of these majestic and protected birds while being splattered over sacred Chumash ground, and add insult to injury without any benefit for the people who live in Lompoc. This bloodshed of innocent golden eagles without the legal restriction is ruthless and barbaric, inhumane, leaving the stain on Lompoc ground. Secondly, this was incredibly irresponsible of this company from the get-go. Why did they not get this permit before they began the project? How does that happen by a multi-mega corporation? Their project was not designed to reduce bird strikes from the beginning, as required by state and federal guidelines. And if they achieve their goal of getting a waived permit, they would have an open end permit over unlimited years with probably very little repercussions on their behalf. That raises the question to me and to the public, and should to you too, if this was a nefarious plan with greed at the root. The Bald and Golden Eagle Protection Act, enacted in 1940 and amended several times since, prohibits anyone without a permit issued by the Secretary of the Interior from taking bald or golden eagles, including their parts, nest, or egg, and Any form of taking or killing an eagle would subject an individual to criminal prosecution and civil penalties. I implore you, board, not to give this company special treatment. This is a violation for the rule of law and for the rule of the people. Thank you so much for your time.
Thank you. Do we have any other online speakers?
Oh, my name is on the screen. It's on the screen.
We do not have any more speakers, Chair Park.
Okay, and I have 2 speaker slips, and I'm reading people's own cursive handwriting, so I might foul up your names, but the first would be Cindy, is it Goff? Goff. Cindy, will you go first? Go up to the podium. And then you have 3 minutes.
Okay, thank you. My name is Cindy Goff. I'm a native of Santa Barbara County, and this is my first time attempting this, but I'm just would like to say that I am opposed to the operation of the wind energy plant without the proper permit, and I'm also concerned about this commission not following the law and turning its head and saying that they'd rather have the energy than taking care of our protected birds and our land. So I just asking that you would consider really what you're looking at, and there are things you can do to still get this energy. And I am disappointed that we don't get it, but the Bay Area does. So thank you very much.
Right, thank you, Mrs. Goff. And the next speaker is Catherine, and I can't read your last name. Did you say Harper?
Harper.
Harper.
My name is Catherine Harper. Good morning.
Go ahead.
I had no intention of doing this, but here I am.
Well,
I'm
go
new
for
to,
it.
I'm new to this project and hearing about this project just 3 days ago, and I'm appalled. And thank you for listening to all these comments. I agree with all the other speakers, and this is news to me, and I'm telling other people who never heard about it at all. It's back in Megalito Canyon, where most people don't drive around and see them. They're already up and operating. I'm against this operation without the proper permits because the golden eagle has no other protection, but this as well as other birds and animals. And so I'm just here to say I'm against it, and thank you for hearing us, and I hope you consider this. Thank you.
Thank you. Do we have any other public comment? All right. Then,
Chair Park, we actually do have another public comment online.
okay,
Stephen Ferry. Or
okay. Mr. Ferry, why don't you go ahead?
Good morning, Chair Park and Commissioners. I'm Steve Ferry, representing Santa Barbara Audubon Society. Audubon has reviewed the latest staff report, which recommends that the Commission vote to allow BayWa to start Operation Strauss without the required Eagle Incidental Take Permit, or ITP. This is a major concession by the county. Audubon respectfully, strongly disagrees with the statement in the latest staff report that, quote, the proposed project provides no less protection to golden eagles and potential impacts remain mitigated to the maximum extent feasible, unquote. By this logic, the ITP would not be necessary because the current proposed project would provide sufficient protection and mitigation for the eagles. However, the U.S. Fish and Wildlife mitigation measures will not be in effect from the time Strauss starts operation until the time the ITP goes into effect, potentially more than 1 year. This leaves golden eagles without the protection of the Fish and Wildlife requirements and mitigation measures for all that time. Because of the reduced mitigations, the county should add additional stronger mitigation measures in order to provide improved protection and mitigation of impacts on birds. We have outlined our 5 recommended mitigation measures in our letter to the PC of August 5th. Since then, we have negotiated repeatedly with BayWa, but unfortunately have been unable to agree on mitigation measures. I now state 3 of our proposed mitigation measures. Catherine Emery will state the other 2. 1, provide an enforcement mechanism to ensure the completion of the ITP. We know that previously delayed submitting their ITP application for over 3 years. We propose that BayWa pay a penalty of $100,000 if county staff determines that BayWa has not actively promoted the completion of the ITP by Fish and Wildlife or does not provide all data needed by Fish and Wildlife in a timely manner. 2, require that the Fish and Wildlife ITP process used for Strauss to be the current process. Fish and Wildlife has proposed a future rule that would revise regulations for the Eagle Take Permit program. However, this proposed rule is not now in effect and will be issued no earlier than the end of this year. The county should require that the Strauss ITP be devised under the present specific Fish and Wildlife ITP rules, unless the county receives a letter from Fish and Wildlife stating that they can no longer process the ITP under the rules in effect as of August 9th, 2023, in other words, today. 3, devise additional mitigation measures in the event that an eagle is killed before the ITP is in place. The ITP will not be in place when BayWa is ready to start operation of Strauss in a few months. As a result, if an eagle is killed before the ITP is issued, there will be no compensatory mitigation for the eagle kill. We suggest that the county impose a penalty of $30,000 per eagle, similar to what has been imposed at other wind farms. Thanks for considering my views.
Okay, I heard a reference to Ms. Emery's going to present on something, but is she signed up for online comment?
Yes, she is.
Okay, I will note with some annoyance, it's hard to manage public comment if people are signing up as we go along. So you have ample opportunity from 9 o'clock in the morning onward to sign up for public comment. I'd ask people to please do that. It's not fair to the other public commenters to have to come into this room and show up at a certain time when everybody else can join on telephone whenever they feel like it. But let's go ahead, Ms. Emery.
Good morning, Chair Park and Commissioners. Thank you for meeting with us. I'm Catherine Emery, Executive Director of Santa Barbara Audubon Society. And I hope you can hear me. Can you all hear me?
Yes.
Okay, great. And just so you know, I did register a couple days ago online, but I appreciate the reminder, so thank you. Santa Barbara Audubon Society supports all forms of renewable energy, including wind energy. We look forward to the start of Strauss operations soon, when the environmental impacts are properly mitigated. Audubon understands that the Planning Commission on July 12th tentatively approved the changes to the Strauss CUP mentioned in the reference case. These changes would allow BayWa to start operation of Strauss without the required Eagle incidental take permit, which, quote unquote, would result in less protected and less enforceable mitigation measures for golden eagles than is provided for by the existing condition, as stated in the county staff report on July 3rd. Allowing BayWa these changes is a major concession by the county. We believe the county should strengthen mitigation measures on Strauss. Santa Barbara Audubon advises that the county modify BayWa's proposed changes to include 5 mitigation measures to improve protection and mitigation of impacts on birds. In addition to the 3 mitigation measures recommended by Mr. Steve Ferry, Santa Barbara Audubon recommends, number 4, we require that identified units demonstrate capability before Strauss starts operation. BayWa's proposed changes states that BayWa shall provide documentation demonstrating the complete installation of active surveillance technology such as identified units. This is insufficient. In order to protect eagles and other large birds, the identified units must be operational. We are pleased to see in BayWa's letter of August 7th that the identified units will be in full operation soon. Nevertheless, we recommend that the language in the proposed change should be modified to say, provide documentation demonstrating the complete installation and satisfactory operational test data of at least 3 active surveillance technology, such as identiflight units, before Strauss operation commences. And number 5, increase the frequency of carcass searches and used dogs. Mitigation measure MMBI-016B currently calls for carcass searches once every 2 weeks at 30% of the turbine generators. This is insufficient. This requirement should be changed to require carcass searches every week at all of the WTGs, and the carcass searches should use dogs. Dogs are much more efficient at finding carcasses than humans. Santa Barbara Audubon hopes that the Planning Commission will strengthen mitigation measures on Strauss to save federally protected birds. Thank you again, Commissioners, for your time.
Okay, thank you. And we have one more public speaker. It's Mr. Bedford. George Bedford, are you here? There you go.
My name's George Bedford, Santa Barbara County resident at 4026 San Miguelito Canyon, unfortunately. And my concern is the roads that have not been fixed, that said were going to be fixed, the amount of equipment they put down in my stream that has not been removed, and no one's going to pay any attention to these dead birds. I'll guarantee you that. You can say all you want about how you want to mitigate it. They're not going to pay attention to it. They'll hide them. And that's about all I got to say. I'm against the project to begin with, and you've destroyed a canyon. So thank you.
Thank you, Mr. Bedford. Okay, do we have any other public comment?
Chair Park, we do not have any other online public comment.
Okay, then let's go to the applicant's rebuttal. Mr. McDougall, or whoever.
Thank you very much, Chair. Obviously, there's a lot of impassioned comments there, some of which I think were ill-informed and not based in fact, but I think the first comment I would like to make is, well, everybody takes the presence and the protection of eagles very seriously. It's a very important factor for us as well as for the Commission. I think everyone can rest assured that the adaptive management plan is what has robustly put that in place, and that is a very significant piece for everybody. I think all of the kind of main concerns around legality, etc., I'm happy to bring in one of my colleagues to discuss that in a second, but we're comfortable in terms of the process. I think two points I would like to make would be, one, that there was always an envisioned condition to allow for us to be operational prior to a permit coming, so we're not changing the substance of the original condition. It's semantics around it. And I would also be very clear that the protections to eagles envisaged throughout all of that condition are not undermined in any way by this. I would like to pick up very quickly on some of the Audubon comments, because we have had a number of discussions with them, and frankly probably just run out of time to come to the Commission today saying we're in full agreement. I think what they are concerned about, we probably feel some of them are unnecessary because they're covered elsewhere, and the others we're keen to do, and some are covered by US Fish and Wildlife Services, so we felt they were better left with our relationship with them rather than opening them up to the county. So we're keen to get to a resolution with them on that. In terms of the primary concern around mitigation was one of the usual kind of financial penalty for any kind of take, and we've certainly made an offer to put that down in whichever way we can, that we would make a contribution to a raptor rehabilitation centre of that amount should that ever happen, and that would be in addition to any other enforcement that would come from the federal agencies, which we still think would be there. So I'll invite Julie Jones from Perkins Coie to address a couple of points as well.
Thank you, Chair and Commissioners. I'm Julie Jones from Perkins Coie. We are counsel for BayWa on the Strauss Wind project. And I wanted to address, without revisiting in too much detail, points that were addressed in your first hearing on July 12th, and that dealt with some of the comments that have been made today. But just first of all, I'd like to reiterate that in terms of providing the same level of protection as the previous version of Condition of Approval 38, we should all remember that Condition of Approval 38 did not require an ITP be in place before the project began. There were two other options at the time, which was to get a letter from U.S. Fish and Wildlife saying they anticipated issuing an ITP, which would have allowed the project to go forward without an ITP in place. And then the third possibility was that U.S. Fish and Wildlife would say, you don't need an ITP, and that is not a proposal that anyone is making here today. So to say that originally the condition of approval required an ITP to be in place before the project began operations is just not correct. Second, the statement has been made that this is the ITP was the only mitigation for impacts to the golden eagles. And as the Commission well knows, and as we've discussed in connection with Condition of Approval 42, there are many provisions of the conditions. It's a long, long list of mitigations for the eagles that are in place. And really, I think what this dispute boils down to is the question of compensatory mitigation for eagles that could occur before the ITP is issued. So if take occurs before the ITP is issued, what would the remedy be? The U.S. Fish and Wildlife, as the Audubon Society has pointed out, has in the past issued penalties of $30,000, amounting to $30,000. And as Gordon has mentioned, the proposal to include $30,000 of mitigation for any eagle taken prior to issuance of the ITP to an organization, a wildlife eagle rehabilitation organization, is conceptually fine. But it's not as if the county didn't already have those many additional protections for the eagles and through the adaptive management program. I would also confirm, as we've stated in the past, that U.S. Fish and Wildlife Service has never, to date, just declined to issue an ITP. So it is our full expectation that an ITP will be issued, and it's a matter of addressing what happens in the meantime. That is what we're talking about here. The claim that the county would somehow be at legal risk of felony liability, the Ninth Circuit has held that does not apply to the permitting agency looking forward as it issues approvals of a project under federal law. And under state law, we're not aware of any prosecutions of local agencies for issuing approvals of projects that are alleged to be in violation of the California Endangered Species Act. And I think that is all I have, but I am, of course, prepared to respond to any other questions you may have.
Mr. Chair, I have a question for this witness.
Yes, go ahead, Commissioner Cooney.
Yes, thank you, Ms. Jones. Just had one question. What is your position on the July enactment of state permit process? Is that something that you're subject to?
As our understanding is that that program is not yet fully operational, and that California Department of Fish and Wildlife doesn't even yet have an eagle expert to run that program. So that if it were to become effective, then that would be, BayWa would follow that process. But we don't know whether it will be in effect. And Gordon, I think, may have more recent information on that.
Thank you. We have been in active discussion with California Department of Fish and Wildlife regarding this, so they are at this point considering what that process would mean for them. Early discussions we've had is they would look to replicate the federal process. So we've invited them in to observe and sit in with the process we're going through with US Fish and Wildlife Services for this permit. So they would look to learn from that and see, and whatever becomes the adapted part, we will be subject to that in due course. But there's nothing in place today, but we've invited them into our process and think that's probably, for them and for everybody, the most constructive way forward.
While we're on this subject, it sounds to me like this may be duplicative of what you're doing, but it may be faster. It may be something you could obtain readily. It would be potentially more protective than the conditions that have been proposed in our staff report of today. So if I or one of my fellow commissioners were to impose a condition that you pursue the state permit as you've started to do, would that be something you could agree to, oppose, or want to discuss?
I guess it's a blank page at the moment. That's my only reaction. I couldn't pursue anything because I wouldn't know what to pursue right now. There is no process. We've spoken to them. They have got an ability to do this. There's nothing active for us to do other than try to work out with them what that is, and we're keen to do that. So we're certainly engaged. We're certainly trying to do what we can. But there would need to be a process for us to follow rather than us create the process.
Well, it sounds like there's an opportunity to submit to regulation that may improve the concerns that many in the public have. And I just wouldn't want you to fire up and not be obligated to follow the process once it's clear.
I assume we are obligated to do that under that legislation, not the county permitting. So I think it's separate. So again, our expectation is we are working with California Department of Fish and Wildlife. We have extensive and enormous mitigation programs with them through this project. So we're very much engaged in all of that. We will be subject to that, just not necessarily through this individual condition. This is a county condition, that's a state condition. So they coexist, but they're not one and the same. So my expectation is I will be subject to that. We will work with it. We will do everything we can with them. We're inviting them into the process to establish what that will be for them and everybody else in the state that's going to be subject to this.
Okay, I appreciate your response. Thank you.
Okay.
Any other questions of the applicant? Oh, Commissioner Bradley.
I do. Just a little bit of a follow-up on that. I can imagine your negotiations with CDFW are lengthy for the existing state permits you have to get. So have they informed you of this impending legislation that, again, they are responsible for implementing? Have you had that discussion, or have they just said it was adopted, but we don't have a program in place and we'll let you know when we get that in action?
Well, as I said, we've had a conversation around what it means. They don't have a program for it. They're not sure at this stage how they're going to implement it. And what we've said is we're in an active process with US Fish and Wildlife Services. Would you like to observe and see how that's working? So they're going to be observers in that, I believe. It's at their discretion, so it's obviously not for me to tell them how to implement their rules. But we're happy to engage and bring them into what we can.
Okay, so but aren't you also in a similar thing with CDFW for incidental take permits?
Oh yes, we are
right.
for other matters.
Right.
Yes, so we're just
So
at the point of concluding all of these. So these have been extensive, yes.
Okay, thank you.
Okay.
Any other questions? Okay, then we'll close the public hearing.
Thank you very much.
We're going to take a break until, is it 10:45? And this is not going to be one of these 10-minute breaks that last 20 minutes. We're going to start at 10:45 on the dot. Good morning. Welcome back to the morning session of our August 9, 2023 County Planning Commission hearing. We're still on item number 2. We've closed public hearing, and now we're at the stage where staff has an opportunity to make further comment, and we have questions to staff. I took the liberty of... Okay. So I'll repeat myself. Welcome to the morning session, the renewed morning session of the County Planning Commission hearing for August 9, 2023. Okay. And we're now at the stage where public comment, public hearing is closed, but staff has the opportunity to make further comments based on what it's heard and to answer questions of the commissioners. I'm actually going to go first with a question I asked of Mr. Zorovich, I think it was Monday, and I know he's done some research on this, and that is to refer to the 5 suggested conditions, additional conditions that the Audubon chapter has suggested, and report to us what you've found in your research, Mr. Zorovich, and what your impression is of what we should do regarding those items.
Thank you, Mr. Chair. So I'll just go down the bulleted list here. First, what it talked about was the headers kind of provide an enforcement mechanism to ensure completion of the ITP. You know, earlier this morning you did kind of talk about speculation that what if they didn't get the ITP and that would be reopening. That's obviously one. What if they didn't, you know, want to come forward with other options? Obviously, this would be then they'd be out of compliance with their condition that requires some sort of ITP. That could result in a notice of violation, which then if they don't pursue that and follow up with abatement options, could result in fines that start at $100 per day and go up from there. So there is kind of an enforcement action already built into our process when you don't comply with the conditions of approval. The next one with regards to the U.S. Fish and Wildlife ITP process, there's talk here that there's obviously going to be a new process, a general process. It's not finalized yet. It's contemplated to be in the beginning of January. In our discussions with the U.S. Fish and Wildlife staff, this other process would be available to projects which have been identified, and specific here to wind energy and birds, in a low risk category, and they believe the Strauss project is not in an area that's identified as low risk. Also, that projects would be eligible for this newer process if they don't have any nests located on site, active nests. So again, there are active nests, there have been on the Strauss site. So in our conversations with the U.S. Fish and Wildlife Service, they would not really be eligible for this newer process, as at least it looks like now. Now, you know, they're not done with that process. They're still reviewing all the comments they got. But when I spoke with them yesterday, their sense was that the Strauss project would not be eligible for this newer process. With regards to the compensatory mitigation up to $30,000, the applicant has offered something. Maybe they'd want to include that in their project description. You know, the U.S. Fish and Wildlife Service has an enforcement arm. Through that enforcement arm, if they felt that for whatever reason there was a take of an eagle, I think they would be eligible to pursue some kind of compensatory or enforcement action against them. So that's really something that we would leave up to the Fish and Wildlife Service, as they already have that in their process. With requirements to demonstrate capability of the Strauss, the operation of the DENA-Flight, it's our understanding, based on conversations we've had with Strauss, that there really is no demonstration that can be done them turning it on. The real information is only available once they start or turn on and operate the DENA-Flight. So that seems like in that mitigation measure, the information that was requested is not really available, because it's not available until they actually turn on the DENA-Flight. And lastly, increase the frequency of carcass searches. This was an interesting one we weren't too familiar with, so it was interesting to look at the end of this. What we determined was certainly we could increase the frequency if your commission would like, and the operator is open to that, to instead of bi-weekly to weekly. And there appears to be some companies around the area that do have dogs that are trained in this way. So it's not something that, there's nothing available here. So if your commission was interested, I would say in pursuing this, we could possibly amend the condition 40, I believe it is, that would allow for more frequent inspections and the use of dogs in the search of carcasses. That concludes what I think what I went over, unless you had questions.
Okay. And
Chair Park.
Does anyone from staff have anything else they want to add in terms of comments on what you've heard today?
Mr. Chair, no, they don't, although I heard one other thing, and that was that there was a note by one of the public commenters that the Strauss project has been constructed and is operational. It's not operational right now. They've erected the wind turbines, but they're not operating, obviously. Just wanted to clarify.
Okay. And let's go to Planning Commissioner's questions. I think, Mr. Freeney, you were first.
Thank you. Thank you for the explanations, Mr. Zorovich. You talked a little bit about compensatory and that the U.S. Fish and Wildlife Service already has a program. So even though they don't have their ITP, Strauss doesn't have their ITP, would they still be under that jurisdiction if a take did occur? So a dog finds an eagle, a carcass. Do they still report that to Fish and Wildlife? Is Fish and Wildlife active in that? Are they overseeing this? What do you got?
Mr. Chair, I believe the conditions as they're worded, that if there is something found, it is reportable to the agencies, so there would be something that's reported. That report would go to the U.S. Fish and Wildlife Service. What they do with that, I couldn't get a definitive answer. They have an enforcement team. I don't know if they would consider this, oh, there's a good faith effort to get the the permit, so they're not going to pursue anything with regards to enforcement, or maybe they would because they waited so long and they didn't get this in place ahead of time. I don't have an answer of how they would treat that. They would be aware that there was a take of an eagle, as you described, if it was found once it's operational. But what they would do with that information and how they would pursue it, I don't know.
Okay, so then they would have to report that to the county, to you, right? And then
yes,
that'd be strike one. And then at strike two, the adaptive management plan would kick in.
Yes.
Okay, thank you.
Okay. And then Commissioner Cooney, I think you were next.
Thank you, Mr. Chair. During the break, I had an opportunity to discuss with staff concern I had about the applicability here of the state effort to duplicate the permit process for an ITP. And I was advised that, I'll let Mr. Briggs say what he said to me in terms of requiring that as a condition.
Mr. Chair and Commissioner Cooney, so during the break, we briefly chatted about the new state program that has been initiated for an ITP for eagles for certain projects, including wind projects. And I think that folks are quickly jumping to, hey, there's this state program that's available. Let's subject the project to the state program, and that's fine. When we spoke to state staff, though, legislatively, this action has been taken. There is really no quote-unquote real program in place yet. Staff has not created a process, a program. Staff have not been trained, assigned, familiar with what they're doing. If someone were to come to the state today and say, hey, we would like to apply for an ITP for an eagle, I'm not sure they would even be able to take in an application. So our initial conversations with CDFW staff were, we are awaiting instructions from our organization on how we are going to implement this program. So yes, legislatively the program has been created. Realistically and functionally, that program is not quite there yet. And I don't have a timeline or an understanding of how long it's going to take for them to create the program so that it's actually usable to a potential applicant.
All right, thank you. Does that answer your question?
I had a follow-up question, and that was, could we adopt a condition today, a condition of approval of the project that imposed a requirement on the applicant to obtain a permit under the California legislation at the time it is possible to do so. The program is up and operating and there are guidelines. It might be months before it is, but at that time, I don't want the applicant to be able to say, well, it doesn't apply to us because we were in operation before it became feasible for us to apply. So I suggested that to Mr. Briggs and Mr. Zorovich, and they said yes, we could develop a condition to that effect.
Okay. And Commissioner Bridley.
First, Mr. Zorovich, could you double explain again what you were responding to in terms of the requirement for the U.S. Fish and Wildlife new ITP process? I mean, what it says is just not, it's now in effect, but I think what we've heard about is that California, and if I get this right, we've got the U.S. Fish and Wildlife that has an ITP program that's well established, and these people and the applicant is in process. We've got a CDFW program that has been legislatively approved, but there's no application process. So you made a comment when you were going through the bullets in the Audubon letter, and I didn't write quickly enough for your number 2 response, which is on the required that the U.S. Fish and Wildlife ITP process used for Strauss be the current process.
Mr. Chair, Commissioner Bridley. So, yeah, I was trying to go through those quickly, so I'll focus on this one again. So apparently, the U.S. Fish and Wildlife Service is now adopting or going through a general rule process which would allow for a more general and perhaps expedited permit for incidental take permits for eagles. But they're still going through that process. They receive public comment on the general rule. They're taking in the comments, considering them, and they expect to finalize their process late this year, early next year.
Okay.
So, and what I was saying, based on my understanding with our conversation with Fish and Wildlife, is that even when that is finalized, it's unlikely that Strauss would be subject to that new expedited process because of the factors I determined. They're not in a low-risk area, and there's been a history of active nests on the site. So that would kick them out of that process, and they'd have to go through the process they're going through now.
Okay. Thank you. I have other questions. It probably is questions. I'm trying to be organized between questions and deliberations. There's a common principle in planning that when you publish the NOP, the existing conditions analysis is frozen at your NOP publication date. And I've seen some cases where really the laws in effect at that time, sorry, I keep on going back and forth for Aaron, are somewhat frozen too. So I have great concern about today's conversations about adding a condition for a future law that maybe is enacted, but there's no application process, but it certainly wasn't in effect when the NOP was published. And we've gone through a long and iterative process with this case, similar to new laws coming out of, or new procedures coming out of U.S. Fish and Wildlife. So I'm wondering if that, principle about having the NOP kind of set your baseline date, does that apply to subsequent legislation? Because if we paused, any project could be subject to newly adopted legislation at a state, local, county level, and nothing would ever finish. So it's probably a county council question, right?
Chair Park and Commissioner Bridley. So the NOP and setting that date is really for the environmental analysis to look at what was there and what is proposed after the project. I'm not aware of any way to freeze what laws apply to a project generally, and that's part of the longer a project takes to be implemented, the risk they take is that the laws may change. There's some exceptions to that with vesting maps and certain circumstances, but generally they're subject to the laws in place at the time they're doing something subject to the law.
Okay, that helps a lot. Secondly, along that train of thought is, I am unsure how many cases in the county reach so far beyond the county's regulations to ensure compliance. What we're talking about here are state and federal legislation and regulations that any applicant spends years complying with. I just finished a 14-year process through 5 public agencies that were not the city of Goleta on a roadway project. So I don't understand how, I'm a little bit concerned where we're going in drawing in all those state and federal legislative acts into our entitlement here. And I'm asking staff is if that's common in these very complicated and high-level energy projects that have state and federal agency requirements no matter what.
Mr. Chair, Commissioner Bradley, for these larger complicated projects, and sometimes even more the less complex projects, we do require that they adhere to whatever state and federal laws are. Sometimes for CTS, on a simpler permit, we'll ask that they obtain a permit. Do we go into the level of detail here that says, oh, it needs to be in place prior to operations, and kind of what the level here? For those simpler permits, no. But it is not uncommon to require or to place a condition on a project to require adherence to other agency permit requirements, particularly when it relates to, I think, the protection of endangered or fully protected species.
Okay, and so in your experience, it's been prior to final clearance of a permit in order for something to begin, as opposed to prior to final issuance of a land use permit? I mean, there's distinct steps there.
Mr. Chair, Commissioner Briley, yeah, the timing for when they obtain that is more vague in other permits. This one, obviously, because of the concerns that were when this project originally went through and the impact to birds and bat mortality, we've kind of placed this now that, oh, it's prior to operation, you shall. So that's, what obviously we're dealing with.
Okay. Thank you. Those are all my questions.
Commissioner Martinez.
Thank you. I don't know if this is really a question for staff or for council, but the way I'm understanding this is this new state law that's coming in or came into effect in July this year. You have the federal ITP, and now you have a new state law, which may be an ITP. That doesn't mean one crosses off the other. In other words, if you don't, you have to get both, no matter what, if it came down to it. But in this instance, we know at least the state one doesn't just dismiss with the federal ITP, is my point. Correct?
Mr. Chair and Commissioner Martinez, that's correct.
Okay.
Now, what's not clear to us at this time is no, I take that back. So yeah, they would be responsible for obtaining each permit independently. One does not supersede or obviate the need to get the other. They are independent permits from independent agencies regulating the same resource.
Okay. And as it stands right now, then, if there was, I know it was suggested by Audubon that if an eagle gets killed, it's $30,000 per eagle. But the way it stands right now is that if there was an implication of eagles being injured, killed, whatever, we really have an administrative remedy in the sense of, hey, you're going to stop doing this, or you're not going to operate at certain hours. That's what we have right now on the books.
That's correct. So the adaptive management plan has built-in triggers. When one bird is taken, certain things happen. When 2 birds are taken, we ramp it up and certain other things happen. So that adaptive management plan that was created by the commission during the original approval had anticipated this and built it into the conditions what would happen after each number of birds was taken.
And I don't know if you can answer this offhand, but in these federal ITP, I imagine that they have also administrative or monetary remedies included within it. They control that, and that's just placed basically either it doesn't supplant, but it most likely supplements what our remedies are.
That's correct. It's
Okay.
additive.
Thank you.
Okay, any other questions of staff? Then let's launch into deliberations. Is somebody dying to go first?
I'll take the first stance
Okay.
here in regards to. I probably think it's maybe the safest, maybe not. I don't know. And listening to today's statements and looking up and reading the Audubon Society letter and also reading the letter from CoLab, I'm up here. I'm not just playing curiosity or logging in my office, but I was looking up these acts. It's called indeed, it is called the Bald and Golden Eagle Protection Act from 1940, and read up on the ITP things in relation to this matter. And there's a lot of shalls in there, in this language in regards to the federal situations. It is not something that is discretionary, and I don't think that at all that myself or even the commission itself is trying to move away from this requirement. It is a requirement. I mean, we're doing everything we can to comply with it. The questions I asked today of staff was in particular as to the statement that was included from the Audubon Society, which they had that concern, which is the consequences of these new requirements that we should implement them on BayWa. Well, that's really dictated by law, at least from my impression, because that was my question. Does it supplant it or does it supplement it? And the clear answer is it supplements it. So there's nothing that's going to be done away with what we're talking about here. And then the issue as to the never-ending, I shouldn't say that, and I should probably move to, I can't unstrike what's already been on public record, so I can't unstrike it, not in court, so it's there. I still have this concern, and I voiced this concern the last time, is that if this process of an application for an ITP, we have no timeline. It could be months, weeks, it could be years. And that's the concern I am hearing from those, at least from the Audubon at least, in regards to this situation that we're in here. And I'm not going to back away from this idea that this process, this application process, was known to the applicant as much as it's known to me today. And being a responsible applicant, I'd imagine that there must have been some efforts to try to address this and not push it off, because the only way I can analogize it to is just by looking at one's own profession. And if I showed up to court and the judge says, "Didn't you file the required document?" And I said, "No, I didn't." And the judge and my client's looking at me saying, "You didn't?" And that would be a very nerve-wracking situation, if not sinking Titanic situation. But and then I'm also looking at the CoLab letter from their staff, from their council, and I thought, to me, yeah, I don't like it when somebody says that we're gonna, you're liable or whatever. Of course, I don't like that language, but the analysis in regards to that letter and the implications of, or the applications of applying the facts to the law, I really appreciate that. And they did cite the law, and I know I have been one who says, hey, if you're going to put some legal situations in front of me, cite the law. And they did, and I looked it up and confirmed a lot of these things. So I'm really on the fence in regards to what's going on here. I can't dismiss the benefits of, looking at even all the new laws that were passed in July. One of those things is yes, it's set a date when we're supposed to be alternative energy. Within these same laws that we're talking about, that I just noted it in there is that they were talking about alternative energy, and wind is specifically identified. There were no exemptions to any of the laws that are currently on the books for these wind projects, and they have to go through the same thing that any other company making an application would go through. So I'm interested to see what the commissioners say. That's why I was interested in going first, because I could hear what you all would say and take that into consideration at the same time. But I just can't back away. Right now, I just can't back away from the idea that this was a condition from the beginning and remains a condition now. And should somebody be allowed to continue on with a condition which was already supposed to be met? Thank you.
Who wants to go next? Commissioner Cooney.
I'm willing to go next because of my concern about the status of this application. I want to say, first of all, that a number of our witnesses were, I think, obviously opposed to anything that would endanger the eagles, regardless of how much attention was paid to the conditions. It was just, we don't like these wind machines. I think that day has come where we, as a society, are obligated to see what we can do to develop alternative sources of energy. And this is one before us with contracts in place, ready to go. And I don't want to slow that process. And after our last meeting discussing this, I came in convinced that subject to the conditions that we apply today, we should not hold this up for what is admitted by all to be a lengthy process. It could be months, it could be years before we could actually see the contracts that are in place in Marin County and other locations would get the benefit of this wind energy. So my bottom line conviction is the project needs to go forward, and I am sensitive to the fact that we could add conditions to what we have that would not impair the beginning of this process. I don't want the applicant to have to go back to the drawing board in any way. However, I think it's a simple matter that we could state, and I haven't the language written out, but we could state today that when the state ITP process is up and operating in accordance with the legislature and the governor's office adoption, that they would be required to apply. So it wouldn't be a case where, because they're 3 months down the line, everything's ready to go on the state level, but they could say to the state, well, we don't have a condition, we're not going to have to apply for the state permit. Whatever value the state permit eventually adds to the picture, I think we should attach to this permit.
Commissioner Bradley.
I'm ready. I was initially not inclined to move in the direction that Commissioner Cooney just outlined, but I think after questioning staff, I'm fine with it. The thing, I just think it has to be very explicit that the applicant is willing to do this revised legislative compliance with the state as well as the federal. I believe was that your intent, Commissioner Cooney, that to also bring in whatever the revisions are to the U.S. Fish and Wildlife ITP process? Or just the state?
The ITP process that has been the problem here is still there. It's still in the conditions, and they'll have to accept whatever conditions are applied to that for this federal permit. But right now, I don't think anybody on the commission knows enough about what the state permit process will require. And all I'm saying is we need a placeholder so that when and if the application becomes feasible to get, this applicant will seek that permit.
Okay, so I'm going to continue on with my thoughts that I wanted to be very explicit with the applicant, and the condition has to state this too, because the state legislation could, their protocol, their implementing ordinance or implementing strategy or application process could actually exempt things that hadn't applied by certain times. So if that's our desire, then I just want it to be super explicit that they do it even if the state legislation somehow allows an exemption for a previously processed application. And I see County Council pointing up. But in generally, I'm okay with the concept. I think it's important to address a lot of the testimony that we had today, and I think it builds on all the good work that the commission did, as well as the applicant, in terms of the adaptive management plan and the 6-month reporting until the ITP is issued. So, Council, did you have something more to guide me?
Chair Park and Commissioners, I have some concern with the county specifying what's done at the state level, just because the state is going to apply their rules however they will. And, if we, for instance, said they had to complete the process, even if found to be exempt, we could get into a tricky situation where they're not able to, and then they're not complying with the condition, but then also can't move forward at the state. So
Maybe the best we can, okay. I that was kind of going back to my original concerns, but so maybe we just say they comply with the state regulation and leave it at that. Okay. I'm okay with that concept. We are in deliberations. The only other thing I want to point out for the public's understanding is that this is a really complicated project, and a lot of the issues that it presents is a trade-off between what's going to happen with these golden eagles and other wildlife on the site and climate change. If you had been here, some of you that are new to the case, when we were having the original hearings, it was full of everybody who said you absolutely have to do it despite the environmental impacts, because climate change is more important right now. So I think that today's hearing is well thought out by Audubon Society, and for CoLab to engage now, that's helpful and very interesting. But I am very clear that this is a trade-off between two noble goals of saving wildlife versus getting wind energy on the grid. So I'm in support of the project and happy to consider whatever we come up with a revised condition per Mr. Cooney's suggestion.
Commissioner Freeney, did you want to comment?
Yes and no.
Yes and no.
But I'll go ahead. It's interesting what CoLab's letter says here about condition 38 and being really taking us out of compliance with the EIR process, and that a supplemental EIR should be prepared, and that may be the most timely and complete analysis. And it would then remove what seems to be, a feeling of emergency that we have to get this project up immediately. They also made the argument that if it got bound up in court, it could take longer than just pursuing the EIR process in addressing the substitution on item 38. it seems to me if wind energy were so important, right, and we were in such dire straits, then that legislative action would have occurred so far, and that they would not be putting the burden on bodies such as the Planning Commission to, if you would, override the existing legislation, which would be to follow the EIR process. I don't think I'm going to gather the votes on that one. The other thing I would do is, it's maybe too complicated, that would be up to staff to tell me on that, is I would follow most of the, I would look into the Audubon 4 points and see if they were redundant, if they weren't already in the actions here. If they're not, then I'd put them in. And finally, I would invoke the $30,000 per take suggestion, and if the U.S. Fish and Wildlife didn't collect it, then we would determine that it gets sent to, the Eagle Rehabilitation Group.
Thank you, Commissioner Farini. I'm going to bring up some newspaper articles I read in the last few days that were, I think, germane to all of this. One was very interesting. It was reported in the Los Angeles Times full-page article in their business section, which is now just one page in that paper, on Saturday. And it was all about a National Audubon Society report that's just been issued that says, notwithstanding the concern about the impact of turbines, power grids on bird life, that the problem of climate change was a far more serious threat to natural wildlife than killings on power lines and turbines, and that the National Audubon Society felt so strongly about this that it actually issued instructions to the local chapters and said, please consider this, because you have some members that want to oppose any deaths at all, and they're missing the big picture. Okay? Very interesting. Then there was an article that came out, I believe it was yesterday, and I can't remember if it was LA Times or New York Times, and it spoke about something that's a focus of the mitigation efforts we've been hearing today for the federal take permits. And that is a new study that was done on the death of eagles and other raptors from electrocution on power lines. And they reported on the dissection and radiographing of 175 raptor carcasses, and found that even though they had all been attributed to death by electrocution, that in fact 2/3 of them contained shotgun pellets and fragmented rifle bullets. And I can remember as a child in Idaho shooting at birds on power lines with a BB gun and never even hitting them. But, there's some people that never grew up, apparently, and still shoot birds on power lines and on transformers and things. And I think the point of this was that this threat to raptors from grids and so forth is somewhat overstated. Now, I will look somewhat cynically at what happens when you go get a take permit. When you go get a take permit from the feds, then if there are losses, you pay into a compensation fund $30,000, which I think is a ridiculously low amount and in fact insulting. And you get to keep killing them, pay your $30,000, and you also mitigate by paying into some fund for guess what? Getting back to power line electrocution, which doesn't really occur in 2/3 of the instances in Wyoming and elsewhere. To me, and I'm going to deliberately mix metaphors here, this whole concern about complying with federal take permits and so forth, it's important, but it's a red herring. By far the greatest protection that we're giving to these golden eagles here in this county is the adaptive management plan that we hammered out. I hammered out 3 years ago, and I jammed it down BayWa's throat with the help of Audubon Society. And the Audubon Society was so excited to get this that they withdrew their threat of appeal and actually withdrew any opposition to the project at our hearing. And it says, I'm going to repeat what staff has said repeatedly here, after 2 deaths are reported, then we reevaluate all of the conditions of operability of this project. This goes light years beyond of the silly little effort that the feds have to mitigate eagle losses, and who knows what the state's going to do. So I think we need to focus on what we already have. We need to recognize this has been a 3-year process, and some of the Johnny-come-latelys of the thing may say, oh no, you're not doing anything to protect the eagles. That's just offensive to me. We're doing a lot to protect the eagles. There's been a focus on BayWa's excuse for not getting the take permit. You know, if BayWa had gotten the take permit, they'd get away with killing eagles at $30,000 a shot or less, and giving money for power line improvement in Wyoming that's completely pointless for protecting birds. Instead now, because they were dumb enough not to apply for this, okay, they're going to get subjected to criminal penalties, which may be very substantial fines, and who knows what else if there are takes. They're taking a much riskier route. But we're going to protect the eagles. This is not a moral issue about BayWa and what its excuses were. This is about protecting the public. And in the public interest, there are legitimate reasons under CEQA, and we've outlined them all. We outlined them at our last hearing, and they're well stated by staff, for modifying this condition, and they're well supported by substantial evidence. Okay, notwithstanding what the San Francisco firm, with its interest in opposing wind, maybe even supporting eagles, I don't know. We can look into people's subjective motivations. I think the law is clear, and we've been well advised by our staff and by our county council. We need to find legitimate reasons under CEQA. We've done it. We should go forward. My mind is open to further conditions if they can be articulated and articulated today in some reasonable form relating to California's new law on this. With respect to the 5 conditions that are suggested by the Audubon Society, I wished I'd seen them at the last hearing 6 weeks ago. In fact, I wished I'd seen them 3 years ago. Here, with getting this letter on file 2 days, it didn't leave staff much time to try to deal with it, but Energy Division did a valiant job of digging into it. We found that most of them are unnecessary or impractical. I can see some value to searching more than 30% of the turbines and doing it more frequently than once every 2 weeks. And if eagle cadaver dogs can do a better job, and we can discern whether these dogs know the difference between eagles that were killed in the last 2 weeks or ones that were killed 20 years ago, then maybe we can look at that. But I'd want to hear more from what other commissioners support. So, to be clear, I support this application as we've modified it in the staff's latest memo, and my mind is open to further modification if some of the commissioners want to be clear about what they want. So where are we, fellow commissioners?
Chair and commissioners, I think staff has prepared some draft language based on the conversation that we've heard this morning. If the commission would like to review that before there's any motion or further deliberations.
I think that's a great idea.
Mr. Chair, so the conversation has kind of bounced around a bit here, and we took the conditions of approval and added some track changes that show the requirement to obtain the state CDFW permit. We also added the use of dogs in the carcass searches. So I'm not sure exactly which concepts you want included in the conditions at this point, but we're happy to show you whatever you would like.
So you've prepared draft language on those various items?
Yes.
Then let's look at it all, and then
it's-
commissioners can decide what they want or don't want.
Okay.
Chair, if I can do a pause real quick.
Sure.
Can we just take a 5-minute break so we can print these out and get them to the commission to look at?
Let's do it. Did you read what they said when they came there? And so I will put down. Okay, let's go. It's still morning, and we're back on the record for item 2 for our August 9, 2023 Planning Commission hearing. What we're going to do is we're going to trail this item while we take up the item 3, whatever it is, the Walker tank, and we'll see if staff can finish its drafting project before then. So when we take up the Walker matter and finish it, we will then address whether we can finish item number 2, the Strauss one, before we go to the lunch or not. And the reason why this may be of importance to people here in the room is that I've spoken with the county council, and we both believe that given that we're looking at some changes in what you've seen so far in terms of the documentation on this item number 2, that will reopen the public hearing for more public comment and also from input from the applicant. Okay? So with all that being said, let's go ahead to item number 3. And will you read that into the record, Ms. Castro?
The following is the hearing on request of Margot Grieg, Walker Trust, to consider the following: case number 22 DVP 05-00018, and to determine that project is exempt from environmental review pursuant to section 15303 of the state guidelines of implementation of the California Environmental Quality Act, CEQA.
All right. Do we have any ex-parte contacts or site visits to report from the planning commissioners?
Mr.
Commissioner
Chair?
Cooney, go ahead.
Yes. I did have a site visit. I then consulted with staff about what I'd seen on the site visit. I didn't have any contact with any of the parties, but wanted to disclose that I had gone to look at the site.
Thank you. Anyone else? Then let's go on to the staff report.
All right, still morning. Good morning, Mr. Chair and members of the commission. My name is Kathleen Volpe, and I will be presenting the proposal for the Walker Trust water tank. Okay, we're good. Here we have a vicinity map of the property to help orient you to the site. The project is located at 3564 Toro Canyon Park Road. It's in the inland area of the Toro Canyon Community Plan. The parcel is accessed from Toro Canyon Park Road, which is shown here by the blue line via an existing driveway. The property is 45.52 acres and is characterized by steep slopes. The project requires a development plan because the development on site exceeds 20,000 square feet in gross floor area. Because the project is located within the MT Toro Zone, a resource protection zone, and includes new development, the decision maker is the Planning Commission. The intent of these zones is to allow reasonable but limited development because of extreme fire hazards, minimum services, and/or environmental constraints, and to encourage preservation. The project is a request for a development plan to authorize construction of development, including a new 47,000-gallon water tank, surrounding retaining wall, and pumping equipment, to permit an existing unpermitted water tank, and to acknowledge the existing permitted development on site, which includes an 8,587 square foot single family dwelling, attached and detached garages, a guest house, a small and large pool, tennis court and trellis, water pump enclosure, emergency generator, and shed. The parcel was established with 2 other lots in 1985, and a building envelope was applied with the creation of the parcel. A majority of the existing permitted development was built between the years of 1991 and 1994, and all development is located within the building envelope. An existing unpermitted water tank is currently located on the subject lot. The purpose of the water tank is to serve as a shared water use to all 3 residences located along the ridge. At higher elevations, water pressure and volume is limited. The existing tank is served by Montecito Water District, and the water is pumped up the hill to the tank. The proposed water tank is for additional fire protection and potable water for the dedicated use of the subject parcel in the event of an emergency. During the last emergency event, power and water were lost. These photos show the existing site conditions. They demonstrate the previously disturbed ground and dense screening by mature trees and existing vegetation. Here we look at the parcel site plan. The red outline depicts the building envelope. The green line depicts the canopy of the mapped ESH oak woodland, and the yellow line shows the required 25-foot ESH buffer. As proposed, all new development in the existing water tank falls outside of the ESH buffer and within the building envelope. Here we have an enlarged site plan to further demonstrate the boundaries. Again, the building envelope is shown by the red line, the ESH buffer by the yellow, and the new development is located within the 2 blue rectangles. The green line depicts tree protection fencing to protect an existing 18-inch oak tree. Here's an elevation of the proposed water tank and retaining walls. The proposed project is consistent with all applicable comprehensive plan policies, including the Torr Canyon Community Plan. Adequate services currently exist to serve the existing development, and the Montecito Water Department issued a certificate of water service availability in June of 2022 for the proposed water tank. The proposed development and existing unpermitted water tank are compatible with the surrounding environment, and all development is limited to the established building envelope, which was created to protect biological resources. Additionally, the project is conditioned to further protect oak trees and to use natural colors and materials to reduce visual impacts. The proposed project is consistent with all applicable LUDC and MT Toro zone development standards. Development is limited to the established building envelope and outside of ESH buffers, which is consistent with the purpose and intent of the MT Toro zone. The project is consistent with height, parking, and setback requirements, and the project is consistent with Ridgeline and Hillside development guidelines. The proposed project can be found exempt through CEQA sections 15303, which allows for the construction of small new structures, including a water tank, retaining walls, and installation of the pumping equipment. Staff recommends that your commission make the required findings for approval of the project, determine the project is exempt from CEQA, and grant approval of the project subject to the conditions of approval. Thank you.
Thank you, Ms. Volpe. Does anyone have questions of Ms. Volpe? I do. You mentioned an unpermitted existing water tank. Approximately how big is it in terms of capacity? It looked like it had a larger footprint than the new water tank.
Mr. Chair, the existing water tank is 45,000 gallon tank, and it's 8 feet tall. I'm not sure of its diameter.
Okay. And are we permitting it as a part of this process?
Mr. Chair, yes, that is correct. There are existing plans within county records that depict the water tank, but there was no permit there was no record of an actual permit for it, so we were including it within this development plan permit.
Okay. Anyone else have questions of staff? All right, then let's move on. Do we have an applicant presentation?
Yes.
I take it this must be via Zoom because I'm hearing a voice and not seeing anybody.
Yeah, Chair and Commissioners, I'm Kent Mixon, the architect for the project. I don't know if the presentation is up from what you guys see, but I'm on the remote Zoom access.
We see you, but not your presentation yet.
Okay. Is that something that the county pulls up?
Yeah.
Yes, we'll put the presentation up.
Okay.
Okay, sir, you may proceed.
Okay. Mr. Commissioner and Commissioners, I'm Kent Mixon, architect for the project from Androlitis Mixon Architects. A lot of this we'll kind of go through. It's a pretty short presentation, but the planner hit on a lot of the same illustrations, but just to kind of reiterate, you can see here that the existing house at 3564 is the subject property. There's two adjacent properties along that ridge that are served by the existing water tank. And you can see here that this is kind of viewing the property from a bird's eye view on the kind of northwest side. You can see the Pacific Ocean out there to the south and the Carpinteria greenhouses below them. And then everything to the north is that ash boundary area where Toro Canyon Park Road is. And then you can see there's hopefully you guys can see that clearly. There's a little speck kind of to the right of what you can see is the tennis court, and that's that existing water tank that you can see here in this bird's eye view. Next slide. And again, as the planner mentioned, this is kind of an overview of the site. It's 45 acres, and you can see the various different structures and pools and tennis court structure, and then the existing utility yard where there's existing pumps and that existing water tank are located. And then we'll zoom in on those. Next slide. And again, this kind of identifies that ash boundary area, the 25-foot buffer, the new pumps proposed and the new water tank proposed, and where that existing water tank is, and the existing pump enclosure. And if we can go to the next slide, it's a little more telling. And so this kind of shows the area of disturbance where the existing generators are, the existing pump houses, and existing water tank. And I'll hit on the question that came up here by one of the commissioners about the existing tank. I don't know how that didn't get permitted, because this project had all three of those houses had quite a bit of scrutiny over the course, and as the planner mentioned, it shows up on various planning documents, but we could not find any record of that being permitted. The purpose of it, I did find a document by, I believe it was the Water District back in '89, I think it was, that until that system was completed, so it almost made it sound like it was under construction, that the water pressure at these houses would be pretty low, especially at the higher elevations, which this house and the one to our east is. The house that was below us was the first one built of the three. So to answer your question about the sizes are different, even though the gallon count is fairly close or similar, the other one, the existing tank, is shorter and has a bigger diameter, and I don't know that diameter right offhand. But because we're kind of squeezed in the area where we need to locate this tank is smaller in diameter but a little taller, and we are proposing to sink it into the ground, and you can see that in the next slide. So you can see there, that's kind of a cross section through the tank. The existing tank is, or the proposed tank is, 18 feet 18 feet 9 inches tall in total height, with including kind of the dome of the tank. And we're proposing to sink it 4 feet in, which would put it about a 15-foot one above the existing grade. You can see to the right of that section, there's an existing berm that exists between what is where the tennis court is located and where this utility yard is. And in that previous illustration we were looking at, there is a retaining wall that surrounds that entire utility yard on the west, south, and east sides. And then it's open on the north side, which is where the esh boundary is, and where it's pretty heavily wooded on that side. There is plantings on this berm on all three sides, so it's you can't even see this from the entry road coming into the property. And then I think the next slide is go through a couple pictures, and you can kind of see the existing utility yard and where it's proposed, right to the in between those existing generators and the existing water tank. And then the next slide shows the location kind of standing in the area where the tank is proposed, looking back towards the west. And as the planner mentioned in the mudslides that happened after that fire incident years ago, this property, and actually all the properties, lost complete power and water access up there. Since that time, I believe I think they have an emergency generator to handle the water situation, but the permits that we recently undertook in the last 2 years for those generators and that propane tank are basically for this property only, and they are for the emergency pumping of water that would be for this new water tank and exterior added exterior fire sprinklers to all of the structures on this property only. So this new tank being proposed would be dedicated solely to this property. The system for this additional exterior sprinklers is a pretty unique system. It has real low water use sprinklers, and they're tied in. Each one is tied into sensors and satellite images that will detect where the fire is coming from and where the fire currently is, and it will deploy only those sprinklers at that particular time. In other words, so not once it triggers, it doesn't mean all the sprinklers are coming on. It fights the fire where it's coming from. And this size of tank is assumed to take care of a two-day firestorm that would occur potentially on this property. And in conclusion, we are happy to comply with the staff and arborist findings to, paint the existing and the new tank to a color that would be compatible with the surrounding vegetation. And also, the arborist is calling for 3 new 15-gallon oak trees because we're removing, I think, a 6-inch oak tree, and we would work with them on the placement of where it would be most beneficial to locate those trees. So with that, that's the end of my presentation, but I'm free to answer any questions you guys may have.
Okay, thank you. Do we have any public comment on this matter?
Chair Park, we do not have anybody online.
Okay.
Anyone in office.
And since we had no public comment, I don't think the applicant needs to rebut anything. And we'll move back to staff. Possibly you've heard something you want to comment on, and even if you don't, maybe fellow commissioners have questions of you.
Staff has no further comments.
Commissioners have any questions? Commissioner Cooney.
Yes, thank you. I spoke yesterday with Mr. Dargill and Ms. Volpe about a concern with regard to the location high on a ridgetop, looking over the Carpinteria Montecito area below, and also that this ridgetop may be visible from above, and what they pointed out to me was the extensive plantings and trees that pretty much screen all of these improvements to an extent that they're not only not visible from off-site, but hardly visible from any place on the property. My concern is that in the event these plantings are either removed or die or are suffer from a fire that goes through, that we have a condition that requires the applicant to replant to the extent that the existing vegetation exists. And I didn't get done what I wanted to do in terms of drafting one. I don't know if staff has had time to do that.
Mr. Chair, Commissioners, yes, we have drafted a condition, and we can bring it up on the screen if the Commission would like to take a look at it.
Let's do that right now.
Right, you made it too small. Mr. Chair, this condition sounds and reads acceptably to me.
Okay. Do any of the other commissioners have comments on this language or questions for staff? Okay, then let's go into deliberations. Commissioner Cooney, would you like to start? It's your district.
Thank you. While the enormous size of this water tank, 47,000 gallons, initially concerned me, but when I visited this site, it was perfectly obvious the vulnerability of this property to wildfires, of which I'm personally familiar with 3, means that this could make a big difference in terms of saving the structures, including the houses, on the property. And the effort's been made by the applicant to screen and minimize the impact of this on any surrounding properties. So I'm prepared to move to approve the project as presented with the landscaping and screening condition that's on the board. If any of my fellow commissioners have anything else to point out, that would certainly be taken into account.
Okay. Any of the other commissioners have comments and deliberations? I have just one, and I'm always concerned about displacement of existing native vegetation. I thought Mr. Spiewak's arborist report was well-written and was pretty clear that there's not much being displaced and that some of what's being affected isn't native or even really desirable. So I'm happy with this as well. Okay, can you go ahead with the motion, Mr. Cooney?
Okay. I move that we make the required findings for approval of the project specified in Attachment A of our staff report, including the CEQA findings. Determine the project is exempt from CEQA pursuant to state CEQA guidelines section 15303 as specified in Attachment C, and approve the project case number 22 DVP 18, subject to the conditions of approval included as Attachment B and as supplemented by the additional condition proposed by staff today.
Do I hear a second? Second. Great. Motion is seconded. Do any of the commissioners have further comments and deliberations now that you've heard what the motion is? No? Then let's vote. All in favor, please say aye.
Aye.
Aye. Aye. The motion's carried unanimously. It took closer to 30 minutes than 20, but there we are. How are we, staff, on back to item number 2 with regard to the drafting of additional language?
Chair and Commissioners, staff has revised condition language that's ready. One option is we could take a quick break, print those out, and circulate to the Commissioners. And then, being that we talked about having additional public comment and having a chance for the applicants to respond to it, probably take that lunch break, allow everybody to review it, and then come back after lunch and just finish up that item.
This is what I want to do. I want to be very fair on this, and that is, let's print it out now. Let's distribute it to everybody, including to Mr. Caldwell, so he can send it to his San Francisco council, right? And then everyone can review this over the lunch hour. Then we'll come back, have comment from public and from the applicant, and of course the commissioners. So can we do that right now?
And Chair, did you want to see it before lunch break, the revised language, or?
No, before, so it
Okay.
can be, so people can look at it over the lunch
So let's
break.
take, if we can take a 5-minute break just so we can print it out, post it online, get it to everybody.
Let's take a 5-minute break
Okay.
and do just that. Okay, we'll go back on the record briefly. We've received a draft of staff's additional language, and that's going to be posted on our website for everyone to see. And for those who are in the room, you'll either be given the thing or it'll be emailed. And then we're going to take a break until 1:35. Okay, we'll return. We'll have public comment and comment from the applicant on this, and go on like that. All right, see you back at 1:35. Welcome back to the County Planning Commission hearing for August 9, 2023. We're now in the afternoon session, and we're at the point where we're going to be discussing some revisions of proposed documents by staff. Staff, let me ask you to take a few minutes to just run through what you've prepared, so we're all looking at the same thing. And then I would ask planning commissioners to forbear from their most difficult questions. So we just ask to clarify. That way we can give the applicant and public some opportunity to make their comments pretty quickly. Thank you, Mr. Briggs.
So, Mr. Chair and Commissioners, the 5 conditions that were encompassed under your requests were pretty lengthy, maybe 10 pages in total. So what I did was I clipped out the pertinent changes and highlighted them on a single page so that we could digest them a little bit more easily.
Okay.
So the following 3 modifications include the changes that you discussed. The first would be language that reflects a $30,000 payment for any eagles taken prior to the applicant obtaining an ITP. And this particular requirement would be placed in the project description, so it would be offered by the applicant. And it reads, if golden eagles are taken prior to the U.S. Fish and Wildlife Service and the CDFW incidental take permits being issued, the owner applicant agrees to make a payment of $30,000 per taken eagle to a raptor protection center. And if we want to get more specific about the recipient of the funds, that's fine, but this is the language that we have for now.
Okay.
All right, moving on. So now we have some language that reflects the request to require the applicant to get a California state incidental take permit through the program that we discussed earlier. This is condition 38. And there are a couple of paragraphs that would be modified. And you can see the language here in red, which reads, and shall commit to obtaining an ITP with CDFW under CESA, which is the California Endangered Species Act, as applicable. The owner applicant shall also commit to obtaining an eagle take authorization from CDFW under the California Endangered Species Act. Note that this species is fully protected under California law. However, CDFW may issue an incidental take permit under CESA under SB 147. Pretty straightforward.
Yeah.
And then the third provision, this would be included in condition 40, and this was the provision that increased the frequency of carcass searches and also includes the use of dogs during those searches. And you can see that we added in red language that says once a week, and that carcass searches shall include the use of dogs trained for their detection.
Okay. And then I noticed you gave us a second page. Is it?
So the second page there is a printout requested by Mr. Caldwell, and I think he'll probably take that up separately. Gotcha. So for now we can focus on the one page with the red lines on it.
Okay. So do any of the commissioners have questions about that page? I see, I don't know what order you turned your lights on, but we'll start with Commissioner Briley.
Oh, I'm sorry. I didn't hear.
Then Commissioner, okay. Then Commissioner Freeney.
It's just more of a side note. So it says 30% on the inspection, and I think it'd be easier to say 1/3. That way, over the 3-week period, they've covered all of the land.
We can do that. That's fine.
Okay.
And then Commissioner Martinez.
Yes, I really just focused on condition number 1, and I was just thinking that when the second sentence, I was thinking it would say the owner applicant shall make a payment, not agrees to, but shall make more mandatory of $30,000 per taken eagle to Raptor Protection Center. I was also suggesting, following that, Raptor Protection Center approved by and you kind of read my mind, like, it's a recognized Raptor, but a Raptor Protection Center that's approved by the county or recognized by the county, and that the payment of that $30,000 shall be confirmed to the county within so many days of the taken eagle. So we're just beginning to end. Those were my only comments, really. Thank you.
Okay. We will, of course, get back to the commission for deliberations, but do you have any other questions right now? Quick comments, suggestions, or asking for clarification? Okay. Secretary Wilson, looks like you got something to say.
Yeah, Mr. Chair and Commissioners, just before I think we're going to hear from the applicants on these. So just for clarification for Commissioner Martinez, that condition number 1 is the project description, and so that's a voluntary proposal that the applicants are going to make, and so that's why the wording "shall" isn't in there, because the applicant's putting that forward. And then in regards to the other comments as far as the timing and identifying that it's approved, we just when the applicants come on, we can get them to agree to those 2 other items. But that's why "shall" isn't in that one, because the applicants are proposing that as part of their project.
Okay. Now, we're reopening the public hearing. So first I want to hear from the applicants. I'd like you to take 5 minutes or less. We can get back to you, but I want to make sure we have time for public comment.
Okay, thank you very much, and thank you to staff for working so quickly on this. I'll just go through the conditions one by one. So the first condition, we are happy to accept that. We are happy to make sure we're not trying to get away from any of these firm commitments. If it's for us to agree to the word "shall" going in per Commissioner Martinez's comment, I'm more than happy for that language to be used. And we're more than happy for the county to select where the recipient goes and any other language. We're very conscious this was the most important, I think, factor for Audubon Society to see this, so it's important to us. On the second amendment, we're comfortable with that. I'll basically state there's obviously the discomfort of what does it actually mean and what are we saying we're going to do, because nobody knows how it works. But as I say, we are very comfortably working with CDFW to help them introduce this, as we're probably the first case they'll have, and we're very comfortable that we'll comply with whatever's going to be required of us in the future on this. On the third change, this causes a bit more concern and difficulty for us, because operationally and strategically we've devised a kind of a search and protocol that's, we would say, at the very tight end of everything that's recommended. We are in compliance with the guidelines that are set out by the California Energy Commission, CDFW and US Fish and Wildlife, to actually set out what it is we are going to do and how we are going to do these searches. Typically, their recommendations would be, depending on what was going on with a site, it should be between 14 and 28 days. So we were already at the very tight end of that and at the most frequent of the spectrum they provide. So we feel we've already got the far end level of this. With regards to the introduction of dogs, we recognise that dogs can, in certain circumstances, add value to this process, but it depends on the terrain and it depends on the circumstances and what they're being asked to do. And generally you would use dogs, and this is all very fresh kind of insight for me, because I've not long spoken to our consultant who we have contracted with and worked out a detailed plan that's already been approved by US Fish and Wildlife for us to do this. So our consultant has explained why and when you do this, and they're available to join the call if that helps. But they have explained to me that in certain circumstances you would use dogs, typically where there is a lot of kind of brush coverage and there's a lot of the terrain is not easily visible. We have very little of that on site. The other complexity we have is much of the site is already protected ground, where we have Obviously, many of us are aware of the Gaviota tar plant, another protected species on the ground. So we haven't considered the implementation or the introduction of dogs to that and any other implications it would have. So from our advisor's side, they would say they never considered dogs to be a requirement because of the terrain and what it is we're looking for. And it would add complexity to necessarily do that as a very easy give. I'm not sure it's as simple as that. And what we have put in is very much at the very furthest end of that spectrum by all these regulatory bodies. So we do feel what we've put in place is very robust and very appropriate for what we have. And any changes of that would actually kick in under the adaptive management plan, would take care of anything should it be required to change. So that was I think that's it from me. If it is helpful, we could get a search expert who could explain how they devise these protocols, if that would be useful.
Okay.
We have them available.
We will get back to you. Let's, because there'll be a rebuttal portion.
Okay.
And we'll have more input from the commissioners at that time, but I want to get some public comment in. Mr. Caldwell, can I lead with you?
Chair Park, members of the commission, Andy Caldwell representing CoLab. I want to, for the record, state we never appeared before the Planning Commission or Board of Supervisors opposing this project. We are not against wind. Not one time did we appear on this. And we're not against it right now. But what we are for is equal application. You're hanging your hat on the monitoring and adaptive management plan. That's what you're hanging your hat on today. I've screenshotted the final EIR. It's mitigation measure BIO 16. The owner applicant will incorporate the monitoring and adaptive management plan into a bird and bat conservation strategy to be submitted to U.S. Fish and Wildlife, California Department of Fish and Game, for their review and approval. That hasn't happened, as far as we know. And then it says additionally, and correct the record here, additionally, prior to beginning operation, the owner applicant will obtain Golden Eagle take authorization from U.S. Fish and Wildlife under the Federal Golden Eagle Protection Act, or will provide the county with a letter from U.S. Fish and Wildlife Service that either such authorization is under review and expected to be issued or is not necessary for the project. The application for take will incorporate all components of the management plan that pertains to eagles and will specify removal, hazards, et cetera. It's not done. We are honestly begging you. They screwed up by not applying for that thing for 3 years. All we're telling you to do, reopen up, supplemental EIR, all the stuff you're doing today, you stick it in there as overriding considerations. We're gone, we're out of here. Just do it by the book. Because I can pretty much guarantee you it's going to take them longer to get the permit if you try to take the shortcut and not do the supplemental EIR. Virtually guarantee it. 3 of you are lawyers. How long does it take to get for us to appeal to the Board of Supervisors, have that hearing, file an injunction, and go to court? The quickest path, we're trying to help them here. We're not against this project. But our members have gotten bludgeoned to death by this county on ESA, and we cannot withstand this issue of somebody getting a free pass, and you guys basically trying to jury rig what should be a supplemental EIR on the fly, when again, prior to operation. Prior to operation. It's in writing. I underlined it for you. Thank you.
Thank you, Mr. Caldwell. Will your attorney be calling in?
Yes, he should be on Zoom, I think.
All right. Do we have any other public comment in the room? Yeah, your rebuttal. Okay. Ms. Castro, do we have public comment that called in?
Yes, we do. So we do have 2 public comments online. Tony, Francois, and then we do have a phone caller also.
And who is that?
I will ask them to speak their name when it's their turn. It's just their phone number. So
I want to follow with the attorney.
It's our bird expert.
Okay. I forgot the attorney's name.
Tony Francois.
Oh, so that's, okay. So, Mr. Francois, why don't you go ahead?
Thank you. Can you hear me?
Yes.
Thank you very much. The only point or refinement I would add to Mr. Caldwell's comments is that the case law is pretty clear that the way to do what you worked through today is with a supplemental EIR, and essentially what you've had the staff work through today is an effort to cobble together what should just be done as a supplemental EIR, and that's under the case law the correct process to follow. That will ensure that the Planning Commission, and if ultimately the Board of Supervisors' decision on this is challenged, it's defensible, and we would encourage you, rather than adopting this today, to just have the staff do this analysis as a supplemental EIR and follow that process properly. Thank you.
Thank you, Mr. Francois. Okay, and we had one other speaker on the telephone.
we do have the phone person that's called in via phone. I did give you access to talk, so you can please state your name. Please dial *6 to unmute.
Hello?
Okay, can you please state your first name and last name?
Oh, sure. My name is Andrea Chatfield. I'm a biologist with Western Ecosystem Technology. I was asked to join the call on behalf of BayWa with any questions regarding their bird and bat fatality monitoring study. I don't have a question at this time.
Do any of the commissioners have a question of this speaker?
Actually, as long as we've got the
Commissioner
expert here. We were looking for some sort of citation about what is a recognized, certified, something or other Raptor Center, so maybe she has a suggestion about how to phrase that.
Oh, yeah. I mean, there is a certification from the state. I'd have to look up the exact terminology for that, but there is a certification process, and yeah, certainly I can look that up if you'd like.
Okay, anyone else?
Yeah. If I may, Julie Jones of Perkins Coie.
Hang on, you'll come back and rebuttal.
Oh,
Just the next thing. So sit down.
Okay, I will do that.
Okay. Any further questions of this speaker? Do we have any additional public comment, either in the room or online or on the phone or from outer space, wherever?
Chair Park, we do not have additional public comment.
Okay. Then now we'll go to rebuttal by the applicant. Try to take 5 minutes or less, but let's see what you're covering.
Okay, firstly, apologies for the confusion there. We'd asked somebody to be available. They've dialed in and they were available for any questions, so it wasn't meant to be an additional comment. So apologies for that. I'll pass over to Julie.
Julie Jones of Perkins Coie, on behalf of BayWa, with just a few responses. First of all, the report that Mr. Caldwell suggested had not been submitted, the bird and bat report. has in fact been submitted to both U.S. Fish and Wildlife and was there another entity to which it was to be submitted, but that work has all been done. Mr. Caldwell just cited the same provision, then proceeded to the same provision in the EIR that is also the condition that we've already discussed, condition 38. So there's nothing different in the EIR from what we have already been discussing. The question of the need for a supplemental or subsequent EIR, the standard for the county to be able to require a supplemental or subsequent EIR is whether the proposal before you shows a substantial, in this case, a substantial increase in the severity of a previously identified environmental impact. And there has not been evidence presented to you that would allow you to make that finding, that where we would stand at the end of the day, if you approve this, would represent a substantial increase in the severity of the impact that you have already identified, and that's under section 15162 of the CEQA guidelines. The cases that Mr. Francois refers to were cases in which the court said we need a supplemental, we either have or we need a supplemental or subsequent EIR. But those were not this case. They involved very different circumstances. I think in one case, the entire deletion of an entire condition of approval. But the overriding rule is still that the Planning Commission or the Board of Supervisors would have to find a significant increase, a substantial increase in the severity of the Golden Eagle impact in order to order up a supplemental or subsequent EIR. Mr. Caldwell also spoke to me during one of our breaks and indicated that he thought that a supplemental or subsequent EIR would just slow things down by 60 days. And 60 days, of course, would not be desirable in any event, but that is not the case. A supplemental or subsequent EIR requires the same public review comment period as a brand new EIR. So the delay associated with a supplemental or subsequent EIR would not be 60 days. You have ample evidence in front of you to find that with the changes proposed, there would be no substantial increase in the severity of the Golden Eagle impact, and therefore ask you to issue that approval. Thank you.
All right, thank you. Let me first ask staff, do you have any comments on what you've heard?
Mr. Chair, no, we don't.
Okay. Normally, I would close the public hearing at this point, but just in case in deliberations some other need for public testimony comes up, I will not at this time. But let me ask that we go into deliberations and find out what the commissioner's point of view is on the additional work that staff has done for conditions or anything else that's on your mind. Oh, Mr. Briggs.
Mr. Chair, just really quick. So during our conversations, we just added one sentence to the project description with regard to the $30,000 payment for an Eagle take. We'd strengthened this language by adding the last sentence, which says confirmation of the payment shall be submitted to the county within 90 days. So we added a timing component.
Got it.
Good.
Okay, fellow commissioners, what do you think of these conditions?
Or last time, I'm going to go again first.
All right, you like this.
So, actually, I appreciate the effort and the energy that's been put into what we have as the recommendations of these, of the additional language. And I think it works because we're accomplishing the end of not getting rid of the very thing that brought us here, that is the failure to get that take permit. Just looking for direction and doing it the right way from council or staff, getting it in there. That's all.
Okay. Any other commissioners have Comments? Commissioner Farini?
Yeah, Mr. McDougall brought up that bringing dogs onto the property via condition 40, that there could be problems there. I didn't know if the commission had a follow-up on that, or if you wanted to leave the language the same.
Do you have an opinion yourself?
I would have to go at this point with what he says, but if we don't know what the real deal is, then does that mean we need to wait and find out? If dogs aren't allowed and we're requiring them to put dogs on and they go tear up tar plant or whatever, what's next?
Okay. Commissioner Bradley, Commissioner Cooney, do you have comments on what you see? Commissioner Cooney.
Mr. Chair, I was, as you know, concerned with the language that's in the project description, having seen it over the lunch hour and looking at it again now. I think it's entirely advantageous to adopt it with the final language added by Mr. Briggs, confirmation within 90 days of the take permit.
Okay. Any further discussion by members of the board members of the Planning Commission? You haven't spoken all afternoon, Ms. Richardson. Let me ask you if you have I was going to say a take, that'd be a bad pun. You have any opinion you would wish to impart to us about whether we need to do a supplemental EIR under the law? Or order one, or whatever it is.
Chair Park and Commissioners, the Planning Commission and Mr. Pettit probably advised us at the last hearing, have the discretion to change mitigation measures if there's a legitimate reason supported by substantial evidence. It's up to your commission to determine if you've met that threshold and you have discretion to move forward with this or take a different action.
But we've heard about this ostensible requirement for a supplemental EIR that was new today. Is how does that intertwine with the CEQA provisions you just described, or does it?
Chair Park and Commissioners, if you conclude that this change does result in new or more severe environmental impacts than what was studied, then you could require additional CEQA review, but that's up to your discretion.
Okay. All right, that helps. Thank you. It looks like the Commission is heading towards a consensus on adoption of these three conditions, with the possible exception of searches using dogs. And let me just poll the Commission so we get this done. Commissioner Bradley, is that an issue for you? Do you think that language should be excluded about dogs or included?
I think it should not be included, and partially because we have extensive biological opinions by professionals, beyond what we have in the room today, except for online. So the concept of using dogs is great. I appreciate that thinking from Audubon, but given the constraints of all the previous analyses and from hearing from the applicant, I would recommend that we don't include that.
Okay. And Commissioner Cooney, what's your impression?
I think this the addition of dogs can be helpful or it could be harmful, but I think this is something that can be dealt with in the application process, so that if either the state of California or the U.S. Fish and Wildlife requires this as an additional condition, that's the place to add it. So I'm fine with it being left out.
Okay, and I think Commissioner Friende, you favored leaving it out?
Yes.
And Commissioner Martinez, do you have an opinion on this?
I actually have a question. I kind of look at the dog as just being the most objective way of somebody actually determining if there is a take or the number of takes. if the dog's not around, who's determining whether an eagle has been taken? Is it self-reporting?
Let Mr. Briggs answer that.
Mr. Chair and Commissioner Martinez, no, the applicant is required to hire a consultant who does
Oh, okay.
the bird and bat surveys.
Okay. And the number of times that the consultant goes out there is already determined within the paperwork or the wording?
Correct. So previously it was going to be every other week, and the commission, through this language here, is going to increase that to weekly, and they're to survey 1/3 of the wind farm weekly.
Okay, so I'm comfortable without the dog then in that instance. Thank you.
Okay. I think I am as well. I mean, I think this is an interesting concept. I'm sure somebody's going to write a novel about it. But perhaps my opinion is colored by our very high publicity murder case that was recently concluded in San Luis Obispo County involving cadaver dogs and dogs sniffing things, cadavers that were there decades ago. And I'm not sure how one would interpret what dogs were doing out there, and I don't want us to get into a process that's ill-defined and leads to another planning commission hearing about how to interpret what dogs think. And so I'd probably favor just leaving it out.
Mr. Chair and Commissioners, clarification, that condition also had a addition to the frequency. Does the condition want to leave that in and just remove the dog reference?
That's how I interpreted what the commission said, from their words, not from their tail wagging or their ears. Okay. Any further discussion by the commission?
Yeah, sure.
Okay, speak.
So the applicant also pointed out that CDFW, U.S. Fish and Wildlife, and CEC all are on this 14 to 28 day guideline. So now we're coming in because we feel it's the right thing to do, but I don't know that we have the evidence nor the expertise to change how they do their operations and their permitting. It's just a concern that I wanted to make sure. I know it's redundant.
Okay. I also have Commissioner Cooney, followed by Commissioner Martinez.
Oh, I'm sorry. No.
Just to respond to Commissioner Freeney, I always listen carefully to what he suggests. I was thinking in my own mind that the fact that there's a different period provided in one of the permits, I don't think would prevent us from saying we want it done every week. I think it's separate, as they say, additive, rather than...
It's more stringent, not less, and we can go that way. Thank you.
I'll say for myself, I do favor the weekly inspection, just because, oh God, the gross experiences we have in life, and watching animal carcasses and how fast they disappear on my farm and elsewhere. I think an eagle carcass that's been there for 2 weeks just might not be there any longer by the time it gets inspected, and you're more likely to find it after a week. Is that expertise? Not much, but what we offer here. Okay. Would one of the commissioners like to try a motion? It looks like Commissioner Cooney's preparing to.
I think staff is... okay. So I'm reading from page 9 of our staff report dated August 1, 2023. Sorry. I'm reading from page 9 of our staff report dated August 1, 2023. I move that we make the required findings for approval of the project specified in attachment A to this staff memo including the CEQA findings. And we determined that the previously certified environmental impact report, 18 EIR 1, is adequate, and no subsequent environmental review is required pursuant to CEQA guidelines sections 15162, attachment C, and approve the project, case number 23 RVP 31, subject to the conditions of approval included as attachment B and as supplemented by the conditions we were provided just before the noon break, specifically an amendment to the project description, amendment to condition 38, and with the removal of the dogs, condition number 40. I'm not sure if I should include also the red paragraph, the owner applicant shall also commit to obtaining Golden Eagle take authorization from CDFW under the California Endangered Species Act, CISA. Note that this species is fully protected under the California law. I really don't need to include that in my motion, but I would like to include the language that the applicant will commit to obtaining the permit.
Sorry, Mr. Chair, I guess you wanted to include condition 38 and then includes the second paragraph, red line, right?
That's a good way, better way to say it. It's all there together, and I want everything included with the exception, and I guess that's in condition 40. The dog reference is in required by condition 40, and in my motion, it's removed.
Sorry, Mr. Chair. How about the 1/3 of the WTGs, which was a suggestion by Commissioner Freeney in that last condition 40 change?
Would you like to amend your motion in that regard, Mr. Cooney?
I thought condition 40 was part of the motion, the way it reads, except in the last sentence, carcass searches shall include the use of dogs trained for carcass detection. That sentence would be omitted, but otherwise, the once every week at 30% of the WTGs, as far as I know, is valid part of the condition.
Mr. Chair?
Yes.
Sorry to interrupt your motion here, but I just wanted to clarify, and hopefully I can here, is that staff had made, while you were talking on the diocese, a minor tweak to that condition 40 that said, where it said once every week, the existing wording is at 30%. We had modified that to say once every week, 1/3 of the wind turbines.
Okay.
So we adjusted from 30% to 1/3 as you suggested. So that's the other clarification we made to that condition.
Okay. Is there anyone on the commission that does not go along with that tweak as described by Mr. Zorovich to 1/3 instead of 30%? All right. And so is that your motion, Mr. Committee, include that?
My motion as supplemented by all the comments, yes.
Yes.
And
Thank
just
you.
to be part of the changing the motion, sorry.
Do you have a
Commissioner
headache yet?
It's getting there.
Secretary Wilson?
We did make those changes in regards to the project description, which was 90 days. I just want to make sure that your motion is including that. It isn't in the printout, but it's on the screen. I just want to make sure that your motion is capturing that, which is we added and approved, the center would be approved by the county, and then confirmation of the payment shall be submitted to the county within 90 days of Eagle Take. So I just want to make sure that's part of the motion.
I'm sorry, I thought I had said that.
I thought so too. Okay. Do I hear a second to this motion? Is that a second?
Just so Commissioner Bradley understands, I won't be supporting the motion, so I can't vote for a second.
Okay. We have a motion, we have a second. Is there need for further deliberation by the commissioners before we vote? All right. Given what Commissioner Freeney just said, I'd like you to conduct a roll call vote.
Commissioner Cooney,
Aye.
Commissioner Briley, Commissioner Park. Oh, sorry. Commissioner Fernie,
No, I'm sorry. No.
Commissioner Martinez,
No.
Chair Park.
Aye. The motion's carried 3-2. Do we have any further business on this matter today? Do we have any further business for this hearing today? Then we're adjourned.